200 and 201. And this is the last provision which I will bother your lordships with the Constituent Assembly debates, my lord, and then I'll come to other submissions, my lord. Please see Government of India Act 1919. This is very relevant because this is directly in question. This is precursor to Article 200. What are the options available for the governor when a bill is presented to him? Is he supposed to sign it as an automated person, as my lord, one word which is
The postman.
he's not a postman. That's what, my lord, my effort would be, and that comes out from the constituent debate. The very nature, in the very manner in which Article 200 is couched, the language which is used, it gives him options. And when I am given 3 options, means I have been given discretion to choose one of them. The word discretion being used or not used will make no consequence if I am given 3 options or 4 options. I'll show that, my lord. Please come to, my lord, section 12 of Government of India Act 1919. And this would be, my lord, relevant, directly relevant for the present purpose. Where a bill has been passed by a local legislative council, the governor, lieutenant governor, or chief commissioner may, instead of declaring that he assents to, or first option, my lord, is granting assent, assents to, or withholds his assent from the bill. Second option, return the bill to the council for reconsideration. Third option, either in whole or in part, together with any amendments which he may recommend, or in cases prescribed by rules under the Principal Act may, and if the rules so require, shall reserve the bill for consideration of the Governor General. That is precedent. So 4 options: assent, withhold, return to the House, or refer it to the Governor General, which is the present day President, for his assent. Where a bill is reserved for the consideration of the Governor General, the following provisions shall apply when it goes to the President in the present terminology. The Governor, Lieutenant Governor, or Chief Commissioner may, at any time within 6 months from the date of reservation of the bill, with the consent of the Governor General, return the bill for further consideration by the Council, with a recommendation that the Council shall consider amendments thereto. The President can refer it back. Instead of the Governor choosing, Governor may choose that I will send it to Governor General, then namely the President. He can say that no, I send it back. B, after any bill so returned has been further considered by the Council, together with any recommendations made by the Governor, Lieutenant Governor, or Chief Commissioner relating thereto, the bill, if reaffirmed with or without amendment, may be again presented to the Governor, Lieutenant Governor, or Chief Commissioner. Any bill reserved for the consideration of the Governor General shall, if assented to by the Governor General within a period of 6 months. Time limit was prescribed by the Act itself for the precedent equivalent, namely the Governor General, to act. And I'll come to, my lord, that as soon as possible part. That is also, my lord, taken care of. From the date of such reservation become law on due publication of such assent, in the same way as a bill assented to by the Governor, Lieutenant Governor, or the Chief Commissioner, but if not assented to by the Governor General within such period of 6 months, shall lapse. Consequence also provided, time limit stipulated, and consequence provided, meaning thereby the time limit is mandatory, not discretionary, and be of no effect unless before expiration of that period, either 1, the bill has been returned by the Governor, Lieutenant Governor, or Chief Commissioner for further consideration by the Council, or in the case of the Council not being in session, a notification has been published of an intention so to return the bill at the commencement of the session. The Governor General may, except where the bill has been reserved for his consideration, instead of assenting to or withholding his assent from any act passed by local legislature, declare that he reserves the act for the signification of his majesty's pleasure. Well, this was a standalone provision because there was someone above the Governor General, the present day President. Here, my lord, President is
There's no one above.
no one above. Assenting to withhold, my lord, therefore, my lord, and I would come to that, my interpretation of the term withhold is that it is not given effect to it. It falls through. That's how the Supreme Court has read. Falls through. And please, my lord, read, my lord, these provisions in this context. Now, 13. Provision for case of failure to pass legislation in Governor's Legislative Council. Where a Governor's Legislative Council has refused leave to introduce or has failed to pass in a form recommended by the Governor any bill relating to a reserved subject, that is, my lord, state list, the Governor may certify that the passage of the bill is essential for the discharge of his responsibility for the subject, and thereupon the bill shall, notwithstanding that the council have not considered thereto, be deemed to have passed. There is a deeming provision made by way of a statute. Deeming provision of a bill having been passed can be made either by a statute or by amendment of the Constitution. I'll come to that little later, my lord, whether that can be done by a judicial verdict, that's a separate argument. And shall, on signature by the Governor, become an act of the local legislature in the form of the bill as originally introduced or proposed to be introduced in the council, etc. My lord, rest of them may not, my lord, assist your lordships. Please come to, my lord, my lord, 72 is the draft bill of the constitutional advisor. And my lord, kindly come to, my lord, first 70, my lord, Assent. This is again 1935 Act. What I read was 1919 Act, now 1935 Act. A bill which has been passed by the Provincial Legislative Assembly, that is, my lord, present day State Assembly, or in case of a province having a legislative council, has been passed by both chambers of the provincial legislature, shall be presented to the Governor, and the Governor, in his discretion, my lord, the other side would harp upon this, that there was a discretion which now no longer exists in Article 200. Therefore, I am highlighting, my lord. In his discretion, shall declare either that one, he assents in his Majesty's name to the bill, second, or that he withholds assent therefrom, third, or that he reserves the bill for consideration of the Governor General, that is, my lord, President, provided that the Governor may, in his discretion, return the bill. This is the fourth option. Return the bill together with a message requesting that the chamber or chambers will reconsider the bill or any specified provisions thereof, and in particular will consider the desirability of introducing any such amendment as he may recommend in his message. And when a bill is so returned, the Chamber of Chambers shall consider it accordingly. It stopped here. So three options, he can straightway say, I withhold, I grant assent. He can say, I withhold the assent, meaning thereby I will show the bill falls through. Third, he may say that no, there is some repugnancy, some violation of fundamental rights, I refer it to the President. And fourth option, in his discretion, he can say that no, it is curable defect in the bill, and therefore I return it with my message that this particular provision is repugnant. There is already a central law occupying the field, and therefore you please reconsider. Or even desirability, that instead of 19 years of age, you consider 21 or any such thing, my lord. I'm just not giving hypothetical examples. But four options were available to the Governor then. Now, my lord, draft constitution, para 72, when Mr. B.N. Rao, Dr. B.N. Rao, my lord, prepared the draft constitution. A bill which has been passed by the Provincial Legislative Assembly, or in case of a province having the Legislative Council, has been passed by both houses of the provincial legislature, shall be presented to the Governor, and the Governor shall declare either that he assents to the bill, 1. Yes. E56 doesn't use the word discussion. Yes. Lord, I was reading 147 as suggested by Lord, by the constitutional advisor. A bill which has been passed by the provincial legislative assembly or in case of a province having legislative council has been passed by both houses of provincial legislature shall be presented to the governor and the governor shall declare either, first option, he assents to the bill, or second option, that he withholds assent therefrom, third option, that he reserves the bill for consideration of the president. Provided that where there is only one house of legislature of a province and the bill has been passed by both the houses of the governor, the governor may, in his discretion, it was initially there, in his discretion, return the bill together with a message requesting that the House will consider the desirability of introducing, I'm not reading it, it's the same.
Almost same.
Except there is no consequence provided. If the House returns it back, now it says governor shall not withhold. It comes, my lord, subsequently. Now, my lord, the committee, the drafting committee.
So, in effect, if on the second occasion, the legislature again reiterates, then the governor will not have any option but to give it as.
Not at this stage.
No.
No, I'm sorry. It was there. The governor shall not withhold assent therefrom. He has no option.
So it is quite in the negative.
Yes.
It gives a mandate that if it is passed.
You have to grant assent.
Like the college.
That could have been used. That's a separate argument. I'm sorry, Malad.
Like the college. Fortunately, we are not on that issue now. So,
taken the same language.
I cannot say anything.
No, we are not on that issue. Let us stick to the case before us.
Now, my lord, please come to, my lord, now draft prepared by the drafting committee at page 145. The same. No real change, your lordship can take it from me, but the drafting committee also goes this way, my lord. Then, in the draft constitution prepared by the drafting committee, now 201, your lordships have
125 and 176.
200 and 201 present. That is, my lord, the subject matter of, my lord, the reference and your lordship's advice. 201, my lord, was drafted by drafting committee like this. When a bill is reserved by a governor.
So there was only one section, now it is bifurcated into two sections.
Into two sections. Because now we have a president and president has a different regime where he is bound by the aid and advice. He does not have, my lord, the choice, etc. I'll come to that. Please have a look. when a bill is reserved by a governor for consideration of the president shall declare either that he assents to the bill or that he withholds assent therefrom. Two options. Third option, provided that where the bill is not a money bill, the president may direct the governor to return the bill to the house, or as the case may be, the houses of the legislature of the state, together with such a message as is mentioned in the proviso to the last preceding article, and when a bill is so returned, the house or houses shall reconsider it accordingly. Please mark this, my lord, within a period of 6 months. This continues. Whenever Constitution intended to provide for a timeline, the Constitution has provided for. This continues even in the present Article 201. And therefore, it is not permissible to lay down any timeline in other articles. I'll come to that. That's a separate point, my lord. Now, my lord, the debate, this debate, my lord, both of us would be relying upon. The other side would also, in fact, there cannot be any other side when it is a presidential reference. But, my lord, the other side point of view, my lord, they would also.
Other point of view.
Other point of view, my lords. They would also rely upon to say that the discretion was taken away. My lord, apropos, my lord, Justice Narsimha's question, whether subsequent debates throw any light on that discretion or not. Because Dr. Ambedkar says that whenever.
That was not what my learned brother pointed out. That after the subsequent articles were discussed, like 200 and 201, wherein discretion was provided, was there a relook on the earlier article which provided for discretion?
No, there was none, but it comes in 200. Because
because when D.T. Krishnamachari and both Dr. Ambedkar, they say that if in subsequent articles, if we do not provide for discussion, then we may have a look at this article.
We will see, because the wording says, my difficulty is that, I'm quoting from his state.
I do not know what.
Difficulty is that we have not as yet come either to Article 175 or 188, nor have we exhausted all the possibilities of other provisions being made, vesting the governor with the discretionary power. He said as and when. We'll see at 200. In all
Your lordships are right. Lord, that one Article 175 debate is.
It was not necessary because in the subsequent articles, they provided for discretion. So there was no question of again having a relook at.
But Lord, this is the debate. Page 146 is that debate which my lords were referring to. But Lord, please bear in mind that in 163, the discretion remained. That aid and advice except subject to, my lord, by or under the Constitution. And I may tell your lordships, subsequently, there are no articles which specifically uses the word discretion. Subsequent to Article 163, there are no articles which confers discretion. But after reading this, my lord, debate, my submission for your lordship's consideration is going to be that if the article itself gives him options to choose from, use or not use of the word discretion does not matter, because he is that you choose from either of these four.
Then the discretion has to be exercised among the options given in that article.
Lord, I'll come to that.
If the article provides for 4 options,
yes,
then the discretion would be restricted to only one of those 4 options.
Correct. I bow down. It cannot be beyond that. Governor is bound by one of those 4 options. But which option to choose from?
It is discretion.
It is his discretion. Lord, for example, for the purpose of granting assent, the Council of Ministers would always say that grant assent, it is our bill. So there is no question of, my lord, he is using discretion.
That will be relatable only to that part of the question where it is sent back to the assembly for reconsideration. And it is coming back to him. At that second stage, will he be entitled to send it back to the president for his approval?
There he would have the discretion.
This is where you are talking about.
That is there, he would have the discretion. He cannot withhold it.
That's your argument.
But, yeah, that's my argument. My lord, but the problem has arisen because of state of Punjab. judgment, not the state of Punjab judgment. I'll come to that, my lord.
But the issue relating to timelines is not relatable to the options.
No, that's a separate point. That's a separate. Your lordships are right. Timeline has nothing to do with the option or discretion, etc. my lord. Since I was there, since I was showing the provision where the constitution itself prescribed time limit, since I was reading the provision which itself provided for time limit, I just as a reference said that whenever the makers wanted, they have provided for the time limit. And if it is required, it can be done by constitutional.
Timeline which you are referring to is for reconsideration by the legislature.
Legislative time.
That is not a
Not the
timeline given
executive
for the governor.
Exactly, that's my case.
Yes.
That's my case. That now you are reading something which the constitution has provided, not provided.
So ultimately, probably, Mr. Solicitor, we, possibly there can't be any serious dispute with regard to the 3 or 4 expressions used in 200. Assent, shall declare, assent, or withhold, send send to the president for advice. And third is that may return. But the word in his discretion has been omitted on the suggestion of Dr. Ambedkar. Earlier the draft was
About
his discretion.
your lordship, absolutely.
Dr. Ambedkar advised that no, we should delete these words. Those were deleted.
Yes.
So these are the options available. Probably the central point of debate will be, what do you mean by withhold?
I'm grateful.
That will
I'm
be the
great.
central point.
I'm
Is it withhold means that after withholding it means that you are not assenting and you are not, you are for the time being withholding yourself. Withholding for what? Either to return to the assembly for reconsideration with your message or advice,
Punjab judgment says.
or you send to the president. For example, there may be a draft bill touching upon or encroaching upon the power of the parliament under list 1. Governor is well within his right to say, state assembly can't pass it. So therefore you can either advise them that look here, you need to look into it. You can't encroach upon list 1. This is not within your domain. Or he will send to the president of India saying, the state has attempted, the state legislature has attempted like this. In my considered opinion, this such a bill will fall under entry number so and so, for which state legislature is incompetent. And Honorable President will take the final call on that. The
Lord-
only issue will be this one. Probably
Yes,
this
yes.
is not
Lord, only issue will be, and I'll come to that after reading this.
how much time now this entire process should be undertaken. That is probably central point.
The time for completing the process. I'll come to
Form an
that.
opinion.
I'll come to, but that's a separate, my lord, argument.
But
Please
we-
allow me, my lord, but since your lordships have given a very right and apt example, the withhold, my lord, whether withhold is a temporary act of withholding, or as the Supreme Court through 5 judge and 7 judge benches have said, that withhold means the bill falls through. Because there are circumstances where, suppose, my lord, normally the legislature is not expected or is not supposed to pass egregious, my lord, something, my lord, very extraordinary bills which are beyond their competence. But suppose, my lord, how we read the Article 200. My lord, suppose a border state passes an legislation which deals with our external affairs, that will permit a particular country's people to enter or not to enter.
You
What?
can respond to these.
Give me a minute,
As per the way you want. You are only pointing out that rest of the, this discussion ultimately leads to the final bill at page 150. And probably thereafter this issue arises.
Your lordships are right. My lord, then he cannot assent. He cannot refer it to the president because it's not a repugnancy issue. He cannot return it to the house because once he returns it to the house and house repasses it, then he is bound, he cannot withhold it. Then he will have to withhold, my lord. And I have given the examples. It is to be used rarely, sparingly. But that's the way the situation is.
Sorry, what is your submission?
Lord, there can be instances.
There are 4 instances, 4 options. Either he assents to the bill
I am not giving you.
or withholds assent therefrom, and that he reserves the bill for the consideration of the president.
President.
So according to you, the withholding of the assent, the second option, can be unlimited.
It's not, my lord, a temporary withholding. My lord, can I go, my lord, a little, my lord, in the chronology so that I can make that point good? Yes, my lord, my answer is yes. That withhold means the bill falls through. That's how, my lord, the 5-judge bench and 7-judge benches have understood, my lord, the Article 200. And I have given examples.
But then, if he doesn't, if he doesn't exercise the option of resending the bill for reconsideration to the governor, still he can withhold it for a time immemorial.
It dies. It dies. It is to be used rarely, but the power is conferred. My lord, rather than, my lord, entering into this debate right now, can I, my lord, just give the background?
Like for example, in the in the Tamil Nadu case, 10 out of 12 bills, after the first consultation, he said, I am withholding these 10. But you are not talking about a situation where he would communicate saying that I have been
It's a declaration. Lord, before I start the arguments on this point, I'm skipping that debate. My lord, debate takes
That you will deal with those aspects independently, is what you're saying.
aspect of.
Aspects on timelines.
He want,
Yes, 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 my lord, that's a separate issue. I'm-
he just wants to explain us the history as to how these
Yes, yes,
provisions came into effect
Yes.
and submission later on.
yes.
Now, my lord, I am on interpretation of Article 200 and 201. Please come to page 150. Let me read it, my lord. The way we believe it requires to be read. 200, assent of the bills. When a bill has been passed by the Legislative Assembly of a state, or in case of a state having Legislative Council, has been passed by both houses of the Legislative Assembly, it shall be presented to the governor. Now, this is the first condition. And the governor shall declare. My lord, this is his obligation, constitutional obligation. He has to make a declaration. What? 4 options. Either that he assents to the bill, or second option, he withholds assent, withhold assent therefrom. Third option, or that he reserves the bill for consideration of the president. I'll come to, my lord, Article 254, which says that this reference would be necessary only if the bill is repugnant to some central law, not otherwise. He cannot refer it for any other reason. That
Referring to the president.
yeah, then he can refer it. He has to refer it. That's the mandate. My lord, if there is a repugnancy with the central law, he will have to refer it. Now the fourth option, provided that the governor may. It doesn't say shall. Governor may. And something would turn when I, my lord, point out.
Mr. The one read. Let's read it again, the first part.
I'll read, my lord. When a bill has been passed by the Legislative Assembly of a state, or in case of a state having Legislative Council have been passed by both houses of legislature of the state, it shall be presented to the governor,
Right.
and the governor shall declare either.
Yes. So declaration has to be in both cases, whether he assents or whether he withholds.
All 4 cases,
No.
all 3 cases.
Yes.
Yes.
That declaration has to be there.
100%.
It is not that he will not make a declaration and withhold it.
Yes, he will have to declare that I have withheld it.
Correct.
Bound, I bound out. That is the only way it can be read. Yes, he has to declare. One of the 3, he will declare either first option, he assents to the bill. Then no dispute will remain.
So according to you, if he declares that it is withheld, the bill is said to be failed.
Yes. It falls through. Supreme Court says, 5 judge and 7.
In other words, what you are saying is, when it is communicated to the assembly that it is withheld, it cannot be placed back before the assembly for reconsideration.
Correct.
Yes.
What you're saying?
Yes.
Wording, the meaning of the word
Refusal
withholding
to
means.
or grant assent.
A declaration in public domain assigning the reasons that these are the reasons I am withholding.
Reasons, there is a separate issue. Declaration that I withhold. Because sometimes, my lord, reasons can be in national security.
So, but then could we not be giving total powers to the governor to sit in and appeal over the?
For my lord, with profound respect. Lord, the powers are given by the Constitution.
Otherwise, the government elected with the majority will be at the whims and fancies of the governor. We will say that
Before I answer that, no, first of all of us derive our powers from the Constitution.
Yes, of course.
We neither give nor take away. Nobody can, my lord. There are 3 organs. But it's not, my lord. Let me, my lord, complete. Then, my lord, I'll be able to answer your lordship's questions, my lord, more effectively. Right now, your lordship's first brush reaction is that if withhold is held to be
A power to reject the bill.
power to reject the bill, it is there. That's my case. I'll have to make it good. Provided that the governor may, my lord, the 4th option.
Yes.
So kindly park that question. I'll answer that question. And
According to you, even if the governor feels that the bill is not correct or lacking something, it is not necessary for him to exercise the powers under the proviso. He may bypass the proviso and still hold that.
therefore, I am requesting your lordships to park that question right now. That's not my case. That's not my case. That's the extreme case visualized in Tamil Nadu, and whether we like it or not, we are burdened with the Tamil Nadu facts. I'm arguing dehorse Tamil Nadu facts. Correct, my lord? So he has three options. He will have to make a declaration that I assent, I withhold, which according to me, bill falls through. I'm not accepting that. I'm taking that argument head on. Yes. Third, if it is repugnant because of Article 254 with some central act,
That's
we
go to
will
the
have
president.
to refer. But there can be an act with the rather bill, which is of such a nature that it may have some provisions which are repugnant. It may have some provisions which may violate somebody's fundamental rights, or it may have some provisions which, according to governor, is not desirable. Desirable. Then, kindly, have
No, we are not responding.
no,
We
your
didn't say anything.
lordship, smile is a good, is a very.
I am always smiling throughout the day.
Please bear with me.
I can't help it if the God has given me to smile.
It's a good thing, my lord. It's a good thing, my lord. Your smiling judge is always, my lord, pleasing to argue before, my lord, and all your lordships are always smiling.
Consider, just bear in your mind that there are two places in which the expression withhold comes in the Constitution, in Article 200. If your argument withhold enables leads to a bill falling flat, once the governor says that I am withholding, then you will have to give it the same meaning in the first proviso last words. Because it again says when it is represented to the governor for assent, the governor shall not withhold assent. So therefore you are saying if once it is fallen, then where is the question of a second occasion? Constitution is saying at this stage you shall not. Keep in mind and answer.
Yes, yes. My lord, can I request for a 5 minutes comfort break, my lord, if your lordships can?
Yes, yes.
Can I go and come back, or?
Yes, so in the meantime, if you want us to.
Yeah.
We'll come back at
5 minutes, my lord.
12:30. 12:22 now.
I am grateful to your lordship for the accommodation.
We hope you are comfortable now.
Yes, yes.
Relief. Yes.
My lord, may I request your lordship? My lord, I have understood, my lord, what is.
Yes, now we will not interrupt you. Yes.
No, I'm not saying. Yeah, it's not an interruption, my lord, your lordship. That dialogue, my lord, only permits us, my lord.
So you first read whatever you want to, and then
My lord, first, my lord,
develop your summary.
let me, my lord, say that the question of withhold, whether it is permanent or a temporary till he returns, is the question. I will show your lordship, my lord, some examples.
So you have said that it is already covered by Punjab judgment.
No, the Punjab judgment, without noting 5 judge and 7 judge judgments, it's a 3 judge judgment. My lord Justice, Chief Justice Chandrachud, Justice Padiwala and Justice Manoj Mishra, without referring to any of the binding 5 judge or 7 judge judgments, have recorded, my lord, the finding that withhold means you have to you read it with the proviso, which I will show and demonstrate, at least attempt to demonstrate that it's.
In ignorance of the earlier 5 judges and 7 judges.
Yes, and I want to show that and what earlier judgments have said on the question of withhold.
This is what
Thereafter, my
you are
lord,
saying. He has read it, took the meaning from the proviso to give a, to read the
the
withhold.
last part, withheld, my lord, while my lord immediately answering, if the way in which, my lord, the Punjab judgment, my lord, understood article, the last part would have been, he shall grant his assent. He shall not withhold. My lord, the power to refer still remains. But that's not, my lord, right now the question. My lord, I have read, my lord, Article 200. Now, Article 201. What happens, my lord, when bill is referred by the governor to the President of India? That is 201. When a bill is reserved by the governor for consideration of the President shall declare either that he assents to the bill or that he withholds assent therefore. Withhold means, my lord, bill falls through. I'll show, my lord, from the judgment. Provided that where the bill is not a money bill, the President may direct the governor to return the bill to the House, or as the case may be, the houses of legislature of the state, together with such a message as in mentioned in the first proviso to Article 200. And when a bill is so returned, the House or houses shall reconsider it accordingly within a period of 6 months. Please mark, my lord, as a separate point, Constitution provides for a time limit. The date of receipt of such message, and if it is again passed by the House or the Houses with or without amendment, it shall be presented again to the President for consideration. It does not say here that thereafter President shall not withhold it. Meaning thereby the ultimate power of the President to withhold means.
So this exercise of returning can continue as many number of times as the president desires. Correct.
And he is thereafter not under an obligation not to withhold, as my lord
As
provides.
the 200 or
200, my lord, provides. Now, please see, my lord, what is, my lord, how I, my lord, beg to interpret this, my lord. My lord, at page 152, I have given, my lord, I am not reading, several provisions, my lord, where governor exercises executive powers.
Yes.
He exercises legislative powers. My lord, there are powers, my lord, which are quasi-legislative in nature. I may not, my lord. Please come to 154. And then immediately I'll switch over to the judgments, my lord, on this. On true construction of Article 200, the governor is entrusted with 4 options. My lord, I have narrated.
You are
Neither
referring to
context.
Page number
154. I'm sorry, 154.
151.
154.
154.
154. Neither contextually nor textually, it is possible to conclude that the term withhold will have to be read as a temporary suspension of power of granting assent till first proviso works out. There is no concept of temporary withholding of any bill. If the framers of the Constitution would have intended to link the term withhold in the main part of Article 200 to read only in the context of the first proviso, two things would have been provided. A, the term withhold in the main part would have been qualified by the term subject to first proviso mentioned therein. In the main part, they would have said that you withhold subject to following the provision. And B, the first proviso would have mentioned that the bill so withheld shall be reconsidered by the House, which is not that. I am going on textual interpretation, Manoj. In other words, the power of withholding in the main part of Article 200 is an independent and unqualified power. However, out of three possible powers contemplated in the main part, having not been resorted to by the governor, by giving an opportunity to the assembly under the first proviso, the governor cannot fall back again on the main part and withhold the bill passed once again, with or without suggestions of the governor. In other words, if the governor wants to withhold the bill, that is resultantly the bill falls through. Please mark these words. These are the words I have borrowed, which are used consistently by the larger benches. The bill falls through, he has to do it at the outset. If he chooses not to exercise that power at the outset, he is denuded of that power if he chooses to return the bill under the first proviso, because of the last part of the first proviso. The governor is expected and empowered to withhold the bill in the main part of Article
It has been held by 5 judges bench.
5 and 1 judge also.
7 judges.
No, my lord, all are 5. I stand corrected. My lord, there is a judgment of Samsher Singh, but that is on discretion, not on withholding. Samsher Singh is 7 judge.
How do you must have dealt in your argument.
Right.
What is the meaning of word withhold?
It's
coming.
It's coming. Therefore, my lord,
Flexible नहीं है, इसके लिए बोला था.
my lord,
So, give the meaning.
Why has this word withhold being used in this?
yes, my lord, withhold has, my lord, its own meaning. And I will show, my lord, why this has a meaning and why that meaning is required to be given in the main part. And what kind of rare contingencies which are contemplated, where you cannot assent.
Normally, the concept of withholding is, suppose there is some dispute, there of 2 crore. Out of that, 1.5 crores is undisputed. Normally, 1.5 would be paid and 50 lakh would be withheld till the dispute is.
My lord, that's not.
It cannot be, in a common parlance that I understand it.
That's in a commercial parlance, yes. My lord, that we withhold this issue. Right now, we withhold the file. But that's not the way in which it is used. That's not the way in which and it will become very clear.
Is there any debate on the word withhold? The Constitutional Assembly debates why this word withhold is being used?
No. Because it has come.
Otherwise, simply they could have said either he grants assent or he refuses to grant assent. Why withhold has been used?
Right from, look, this word has been taken from 1919 Act, 1935 Act, and now present Act. So it is not debated in Parliament. We will have to independently examine. Your lordships will have to examine. We will assist your lordships in that. But I'm just right now, my lord, please consider, without keeping in mind some egregious, my lord, facts where someone may withhold without any application of mind or just out of political frustrations. I'm just trying, my lord, to say that the governor is not that way powerless. He has 3 options, subject to the 4th option being exercised, my lord, and all 4 options are independent of each other. Now, please see, the governor is expected, para 97 at page 155. The governor is expected and empowered to withhold the bill in the main part of the Article 200 when he finds that the entire bill is beyond the legislative competence of the legislature. Then he can't return it. If the entire bill covers, my lord, atomic energy or defense or external affairs.
Then you can send it to the president.
It's repugnancy only, my lord, if the entire, allow. Kindly allow me, my lord, it would, then it's not a question of repugnance. It's complete lack of legislative competence. It would be, my lord, ultra vires. Then two, the entire bill violates some constitutional provision or some fundamental rights. Entire bill. If it is a part of it, he can say that I refer it to you and you
Delete it, amend it and
delete
come
it.
back.
If you still continue it, I can't withhold it, then it would be set aside by the Supreme Court if challenged, or the High Court if challenged. Even though the bill is within legislative competence and does not violate any fundamental rights, it is so manifestly arbitrary that it cannot be assented to. This is where, my lord, his statesmanly discretion would come, and I have given the examples. Please, my lord, minutely observe, because this is how, based upon your lordship's opinion, the polity of the country would govern. My lord, I am not arguing that present government is in center is a political party, state as a B political party. My lord, it can be reverse also. There are, my lord, political parties in the state, which is, my lord, same party at the center. So we are not, my lord, on conferring discretion on the governor to my lord, kill the bill. That's not, my lord, the idea. It's really the interpretation of the word withhold. Political parties will keep on changing, my lord, in the respective.
We are not concerned with that. We are only concerned with
yes.
provision as it is.
So therefore, my lord, my attempt is as a neutral student of law. This is how I perceive the constitution interpretation to be. Even, my lord, 98. In case the governor feels that either only a part of a bill is beyond the legislative competence, or a part of the bill which violates some constitutional provision or abridges fundamental rights, he may return the bill so as to allow the legislature to cure the defect. The first proviso in case of a bill where the defect found by the governor is curable. When the governor feels that some part is curable, if you make a legislation for, say, defense of India, then it's not a curable bill. And I would not, as a governor, do that. I'll return it because thereafter I can't even withhold it. So that is where the term withhold at the first instance comes. Then 99. If the above interpretation is not given, it will result in disastrous consequences. Normally, it is presumed that all legislatures, in their collective wisdom, will not pass a bill which is manifestly unjust or arbitrary in its entirety. The power of withholding of the bill in the main provision, therefore, shall have to be used sparingly and only in extraordinary situations, when the very constitutional existence of the governor, who represents the democratic will of the nation manifested by the President of India, would be frustrated. Now see, my lord, examples I have given. These are hypothetical examples. For example, if the legislature were to pass following bills, the governor would be abdicating his duty if he does not withhold the bills, as he can neither assent to the bill nor reserve the bill for presidential reference. 1. If the legislature were to remove the concept of reservation itself in the entire state. 2. If the legislature, while removing the reservation based upon the parameters of Article 15 and 16, provides for reservation only based on religion, that only Hindus will get reservation, or Muslims only will get reservation. 15, 16, we are not bound. Third, one state legislature passing a bill preventing residents of other states from entering in that state. Lord, this is a state subject. But the governor may feel, and this has happened, my lord, I'm a slight deviation. This has happened not by way of a legislation during COVID. I'll not name the states, my lord, and everyone was doing in their own right. There was, my lord, one state whose hospitals were flooded with patients. So they were sending the patients to the neighboring states. And the neighboring states was fearing that we will also now feel shortage.
That matter was before me.
Your lordship, my lord, knows. So, my lord, barricades were created that one state people will not come in the other state. It was, my lord, a different fact situation. But suppose a bill is passed. I'm just giving, my lord, an example. The state legislature mandating use of only one particular language as a mandatory requirement for all residents of that state. Look, it is, my lord, a subject of the state list. It can do. The legislature excludes a particular class of people from exercising right to vote, either based on caste, sex, education, or any other ground. Earlier, my lord, only there was, my lord, a limited franchise. All citizens of India were not entitled to vote pre-constitution. A bill is passed by legislature giving complete immunity to the entire cabinet or all elected members from criminal prosecution. Well, then I cannot, as a governor, act on the aid and advice of the, for the very nature of things, my lords. A bill prohibiting central agencies like Income Tax Authority, etc., from exercising their statutory powers within the geographical limits of that state. A bill providing for provisions which undermine the authority of high constitutional functionaries like the President, the Prime Minister, the judges of the Honorable Supreme Court, etc. Now, last, a bill which deals with jurisdiction of the Honorable Supreme Court of India itself. Lord, before I examine this, please see the second proviso to Article 200. Second proviso, my lord, please come back to page 150. This is the classic example, my lords. My lord, I'm not saying, my lord, elected people are responsible people. They act through their collective wisdom. But there can be one circumstance out of 1,000 where such an aberration happen. Lord, please see the second proviso to Article 200, my lords. Provided further that, your lordship gets, my lord, the governor shall not assent to. My lord, first proviso said he may, my lord, return it to the house. Governor shall not assent to, but shall reserve for the consideration of the president any bill which, in the opinion of the governor, would, if it became law, so derogate from the powers of the High Court as to endanger the position which the court is, by the position of which that court is by this constitution designed to fill. Lord, suppose the act says something, and my lord, as per the true reading, there can be a local law with regard to the powers of the High Court that would be mandatorily subject to presidential assent. We are not concerned with that.
Could it not be read in that manner that wherever the Constitution provided as to in which cases the assent should not be granted, it has so specifically provided?
I'm on a different point. Forget, my lord, High Court. Suppose the legislature passes some act.
When a specific power has been granted to the governor, not to assent to in a particular circumstance, and can it not be read that that power is not granted in other matters?
No, it cannot grant, my lord. I'll come, my lord, on that textual interpretation also. Yes, but I'm just giving an example that suppose legislature passes a bill which directly deals with the powers of the Supreme Court. If it is High Court, I'm not on, my lord, whether I show that, my lord, only to show the absurdity of the potential bill. Your lordships are trying to find a solution, my lord, find some conclusion. I'm still on, my lord, the problem. And after your lordship sees the problem, my lord, possibly your lordship may be in a better position to find out the solution. Suppose, my lord, in case of a High Court, the governor is bound to send it. In other cases, he may not. That's the discretion, because the main part says he may assent, he may withhold, he may refer. But proviso say he shall refer. So I am using it against, my lord, the proposition. Please see, my lord, just to immediately answer your lordship's question, the main provision says the governor shall be houses the legislature of the state. It shall be presented to the governor, shall declare that either he assents or he does this or he does this. So there are three options, but here there is no option. Here he has to reserve it for the president. And therefore, my lord, my submission that in the main part, there are three options available, gets 45. Lord, be that as it may, my lord, I'll come to that. Now, my lord, please see para 104. It is pertinent to note that nowhere in the substantive part of Article 200, the term as soon as possible has been used. So this is again on the time, but when we are on Article 200, as soon as possible is proviso when he returns the bill. It was there earlier with time limit in the pre-constitution regime, which was taken away. It is pertinent to note that nowhere in the subsequent part of Article 200, the term as soon as possible has been used, which means that the Constitution did not intend to put any sense of time limit during the exercise of first three options. Moreover, the governor under substantive part of Article 200 can simply sit or withhold assent to a bill if he believes that the bill is unconstitutional and beyond any remedial changes, in which case the bill shall fall through or lapse, as has been observed in several decisions of this honorable court, referred hereunder. The framers of the Constitution consciously avoided putting any timeline for exercise of powers either under Article 200 and 201, which is evident from the fact. Well, this is again on the question of timeline, but let me complete this, my lord, so that also assists your lordships. The time limit prescribed as shown in the history was consciously dropped in Article 111 and was replaced by the expression as soon as possible. And B, the very next Article 201 in its proviso stipulates the time limit for 6 months. Now, my lord, I have given dictionary meaning of the term withhold.
The time limit of 6 months is for the house, not for the.
Not for the governor or the
governor or the president.
No. My lord, the
That is for the house to reconsider.
I'm grateful. So, my lord,
It could be read within 6 months. The house doesn't reconsider.
it lapses.
Then the bill will lapse.
Lapse. My lord, the point I'm making is not what happens to the bill. The point I'm trying to make is that whenever time is stipulated, it is provided for. You cannot read into it. It amounts to amendment of the Constitution. That's, my lord, a separate point, my lord, that I'll come to that. My lord, now, what is the dictionary meaning of the term withhold? This is not considered by, my lord, the debate in Constituent Assembly debates, as your lordships had asked me. My lord, 106. My lord, as per the new international dictionary, withhold means to hold back, keep from action, to desist or refrain from granting, giving or allowing, keeping one possession or control. Refusing is also a part of the term withhold. Refrain from granting is also. Then return means to go back or come back again, to pass back to an earlier passover. Then, my lord, Black's Law Dictionary says withhold means to retain in one's possession that which belongs to or is claimed by another, and return means to bring, carry, or send back, the place in the custody, to place in the custody of, to restore, to redeliver, to send back. Now, my lords, kindly come to 108. It is of utmost relevance to note that the constitutional requirement of expediency or a sense of urgency is incumbent upon the governor only when he decides to return the bill to the state legislature for reconsideration. This is evident from the expression, which I'll come to little later, my lords. My lord, please now come to my lord, directly, Lord, the judgment.
Which judgment, please?
I'll just, my lord, please come to page 164. No, I'm sorry, my lord, no, not Keshwan. My lord, page 168. Then I'll take your lordship, my lord, to the potential acts which are, my lord, there are possible acts under the state list within the legislative competence of the state legislature, but cannot be assented to. There is no question of referring to the president, and returning is out of question, because even if I return it as a governor and if it comes back, then I have no power of withholding. So I'll have to use that discretion on the first occasion. I have given the examples, I'll come to little later. Well, okay, kindly, my lord, have a look at page 166, some examples, my lord. Where, what would the governor do, my lord? He's not just a postman. He represents the Union of India, appointed by the president. President is elected by the entire nation by way of an indirect election. And that is also a way of democratic expression, my lord. An individual who is not directly elected is no lesser than the individual who is indirectly elected. And again, the president acts as per aid and advice of Council of Ministers. And Council of Ministers are responsible to the entire parliament. This is the framework, my lord. This is the check and balance, my lord, which is there. Please come to page 166.
Yes.
My lord, Chief. 166. Well, these are the examples, my lord. A legislative session bill fixes only 2 sitting days per year. It is presented before the governor. Lord, then a confidence motion bill requiring 2/3 supermajority to test the council's confidence, directly contrary to the constitution, etc., etc. Now, my lord, kindly come to page 168, the case law. My lord, before I read the case law, Lord, the 2-judge bench in Tamil Nadu, forget the facts, I repeatedly say, my lord, the 2-judge bench in Tamil Nadu relies upon a 3-judge bench in state of Punjab versus Union of India. State of Punjab takes the view that the word withhold will have to be read with first proviso, that you withhold and return, which in my submission is erroneous on textual interpretation and is in ignorance of several 5-judge bench judgments exactly on the point. And those judgments, my lord, now I place for your lordship's consideration. Page 1.
Looking at case law, there are-
We may start, my lord, at 2, my lord.
withholding you for 15 minutes.
No, my lord, on the contrary. That was, my lord, temporary. This is not withholding as, my lord, we understand.
That was withholding as Mr. Civil and the others understand.
Yes.
Probably is on your side today.
Always this side.
Always on?
On the wrong
He is
side.
always on the right side.
Wrong side.
We are always on the right side of law. My lord, we are always on your lordship's right side.
No, no. Last week, Mr. Kaur was on this side.
And we were on the same side,
You were-
opposing each other.
You were on the same side
Opposing.
till you change your view after the review.
Lordship's.
Which I have not really made more for a cup of coffee.
Yeah.
Discussing Great.
My lord, on this withholding, my lord, let me say something. My lord, I have one distinct advantage. And therefore, my lord, what I am saying is really on the interpretation of the Constitution. Why I say I have a distinct advantage. I had been a law officer of a state where state government was of a different political dispensation, central government was of a separate political dispensation.
It's a reverse situation.
Today, it is a reverse situation. So
That time it was a reverse situation.
it was a reverse situation. my lord. Today also,
Just
today.
you would have been that side and you would have been this
Yeah,
side.
yes. So I know, my
You would
lord.
not have been on this side. You would have been somewhere else.
Lordships are right. So, my lord, functionally, how, my lord, it functions, my lord, I'm aware of it. So it's not, my lord, my attempt to protect the power of the governor anyhow. But, lord, I must, my lord, request your lordships that these are all plenary constitutional powers vested upon high constitutional functionaries. A possibility of misuse or abuse may perhaps not guide your lordship's interpretation. But for example,
The presumption is that the power in such high constitutional functionaries will be exercised bona fide.
correct, my lords. My lord, time and again, your lordships, while sitting in the Supreme Court or on the division bench, have said that this was an abuse of writ jurisdiction. But then the problem is not with the writ jurisdiction. If we examine the contours of writ jurisdiction, it will have to be examined that it would be used for the purpose it is conferred upon the Constitution. My lord, now before I take your lordships to the judgments, may I request your lordships to read 20, 200 and 201, the way I like to read. And I am reading it as a student of law, the way it is to be construed. If there is a power of withhold, as I understand, my lord, let us not give any interpretation which kills the power. Whoever is the governor, whichever is the party in power in state, center, doesn't really matter. But kindly have a look at, my lord, even at the cost of repetition, my lord, 150, my lord. Please have a look at it, my lords. And then, my lord, I'll immediately come to the judgments. When page 150. When a bill has been passed by Legislative Assembly of the state or the council, it shall be presented to the governor and the governor shall declare. Either, my lord, would mean a choice. Either that he assents to the bill or, my lord, this is the second option, he withholds assent therefrom. So I'm withholding the assent of the bill. What is the meaning of withhold? I'll come to. Or that he reserves the bill for consideration of the president. He will have one of these three. Provided that the governor may, here it's not shall. Fourth option is given. As soon as possible after presentation of him to the bill for assent, return the bill if it is not a money bill together with a message requesting that the house or houses will reconsider the bill or any specified provisions thereof, and in particular will consider the desirability of introducing any such amendment as he may recommend in this message. And when a bill is so returned, the house or houses shall reconsider the bill accordingly. And if the bill is passed again by the house or houses with or without amendment and presented to the governor for assent, please mark, the governor shall not withhold assent therefrom. My lord, how I give the meaning of the term withhold used in the proviso? That you will not kill it thereafter. Both words are used in the same provision and has the same meaning. Correct, my lord? Now, going it a little further, my lord, suppose he reserves it for the president. Then 201 comes into play. Please have a look, my lord. When a bill is reserved by the governor for the consideration of the president shall declare either that he assents to the bill or that he withholds assent therefrom. My lord, we take it that withhold means temporarily withholding. Then please see, my lord, the distinction in the proviso. Provided that where the bill is not a money bill, the president may direct the governor to so and so, so and so, so and so within 6 months of the date of receipt of such message, and if it is again passed by the House or the Houses with or without amendment, it shall be presented again to the president. Because there is nothing, then it stands withheld. Because there is nothing above the president. That does not, it neither says, then the governor, president shall assent to the bill. So, my lord, both the provisions in the same document, namely the Constitution, word withhold used at two places in Article 201, Lord, leads in my submission to only one conclusion, that withhold means in rarest of rare cases. But that, no, sorry, this cannot be done. And I have given instances. For example, and without, my lord, giving any real instances, central passes a law and some state legislature central means parliament passes the law, and some state passes a law based upon whatever considerations, that this law will not apply in my state, and the bill is presented before the governor. Can he assent? Answer is no. Can he refer it to the president? Answer is no, because it's palpably wrong. He can't return it because then he will be losing his right to withhold. Then, my lord, withhold is only in rarest of rare cases, in, my lord, exceptional circumstances, and therefore I said that where his existence as a constitutional functionary and his oath of office of defending the Constitution requires him that I will have to withhold, because he is the only person apart from the president who takes oath of defending the Constitution. Unless, my lord, this is read, the governor's office will merely become a post office. He can either assent or withhold it and send it back to the House. And if the House says, no, nothing doing, we go ahead, then he cannot withhold, or as a postman, he will send it to the president. I don't think, my lord, the president's position is envisaged in the Constitution as a postman. He has, my lord, a wisdom. And in real life, my lord, how things work out, I can tell your lordships, my lord. Lord, as a matter of fact, every matter doesn't come to your lordships. Lord, governors are also seasoned people. Political leaders are also seasoned people, irrespective of the party they represent. They have, Lord, years of political experience, public service, my lord, to their credit. What happens is, my lord, whenever a bill is presented, Lord, generally, the governor calls the chief minister and says that these two provisions are doubtful. And I would have very serious reservations. If it is repugnant, I'll have to refer it to the president. Sometimes, my lord, the chief minister also agrees that, all right, we also don't labor much on this. I can promise you, you return it to the House, we'll get it sorted out. And the matters are sorted out. Lord, every problem which may arise under the functioning of the Constitution may not have an answer or a solution in legal proceedings. Lord, when the matter is referred, when the bill is referred to the President of India, there is a procedure stipulated under the office memorandum. Lord, it goes to the President's house. The President's house narrates what are the repugnancies, which provision is repugnant, how it is repugnant, whether it is repugnant. Thereafter, it is sent to the Ministry of Law as well as ministry which is concerned ministry, which is called the nodal ministry. If it's education, it goes to education ministry. Agriculture, it goes to agricultural ministry. Then their feedback is received. That all right, there is some repugnancy, but both can coexist. It will, because why there is a requirement of presidential assent in some cases, that the bill of the state legislature should not be in conflict with the national policy formulated by the parliament. And therefore, that is the ground on which the nodal agency says that though there is a deviation in the state law, it is in fact not affecting the national policy. It is a state-specific provision, though repugnant to the central law. Then the president gives the assent. And otherwise, my lord, if in some cases, my lord, the president returns the bill, and if the bill is, my lord, again passed, it comes back to the president, and then it dies, it lapses. Because Article 201 proviso does not stipulate any my lord, consequence. My lord, if we were to accept, my lord, if your lordships were to accept the term withhold in the main provision of Article 200 to mean temporarily decide not to grant assent immediately. Look, kindly see, this is third angle. Lord, suppose the main part of 200 would have contemplated that withhold means kind of suspension of my powers, that I'll not withhold. And as state of Punjab judgment says, I will refer it to the House. Then the word used would have been, if the House returns, the president shall grant assent. But it says it will thereafter not withhold. Means your right to withhold ends if you do not exercise the first time. Otherwise, my lord, the only meaning, my lord, which we can give, if, my lord, the interpretation given by Tamil Nadu is right, that proviso last part says that if the bill is returned back by the House after reconsideration, he will grant assent, which is not there. He will not withhold it. That is, my lord, the answer. Now, please come to the judgments, my lord. Page 168, my lord. The first judgment is Kameshwar Singh. Start with the judgment, page 168. But, my lord, power being plenary in nature, it has to be left to his constitutional discretion, my lord, whether it is a case exceptional, not exceptional, my lord, that he will have to decide, my lord. That's the way, my lord, constitutional functionaries' powers, functions, responsibilities, limitations, they are, my lord, interpreted. That's my respect.
Exercise of power under the Constitution is never in a vacuum. When the laws were made originally, it was an ideal situation was contemplated. Take classic example, bench schedule. When the law was made, everybody supported. The biggest authority who we all can rely on is the speaker. Speaker is the best authority, so therefore he should be the adjudicator. Now today, if we are asked to interpret bench schedule, where a challenge is made to the powers exercised by the speaker, we would, with our experience, decide it in a different manner. Constitution is a Interpretation is a process. You take into account how the system is working, and it can't be frozen at a time when the article is made and what ideal situation was there at that point of
My
time.
lords are
So
absolute.
we will interpret it on the basis of how these constitutional functionaries are working and how the provisions have to be interpreted. But without reference to the political process which happens, and it will be rather difficult for a
About
constitutional
which the
interpretation.
court would
Can-
have minimum knowledge, my lords.
So,
Possibly.
can the interpretation be static?
Ah,
Or
No,
it
no,
has
the
to be organic?
constitution is a living document. It's
It's a
interpreted.
living document, and like in that Telangana case, it was sought to be argued that in earlier constitution benches, no time limit was framed as to within how much time the honorable speaker should decide it. For the first time, in case of Justice Nariman decided. It was sought to be argued, but then
exactly.
I observed that when the bill was discussed for amending the constitution, Mr. Ashok Sen, who was the then law minister, he said that our experience is that in the courts, the matters are pending for so long that in many of the matters, the petitions become infructuous. So he gave an example of the Congress symbol. He said that though, I think it was initially well, Chori, I think, popular card, and then it was changed to
No, it was cow and calf. My lord.
what did it be? Because so he said that by the time we own the proceedings before the election commission, the proceedings had become infructuous, and we had already succeeded on a different symbol. And therefore, in order to ensure experiences in the matter, it was decided that the power should be given to the honorable speaker. But with the experience, so I observed in that at that time they did not anticipate when the earlier constitution bench decided the matter that the speaker should result the matters in a situation which ends in operation successful, patient dead.
That happens, my lord, in court also, but I'll come to that. There is one judgment, my lord, that therefore I say that inability for good reasons, bad reasons of one organ to do what is expected would not empower another organ to take over. My lord, I'll come to that, my lord, because
We believe in separation of powers, but then
no, Mr. Sen was right, and he could say that because he was in parliament with, my lord, privileges attached to it, my lord. But your lordships would also be, my lord, aware, and your lordships are aware, that the speaker under the tension.
so that we are, I already observed that we are issuing
Yeah, Lord,
maximus because the speaker has been held to be a tribunal amenable to the
Therefore-
jurisdiction of this court and Article
Therefore,
26 and
that's the
227.
point, my lord, he is
And-
a
and-
tribunal.
And he does not enjoy the constitutional immunity as a speaker because the proceedings before the speaker are not the
Is a tribunal, it's
they
not
are
within
not
the
the
house.
proceedings before the legislative council, and so I observed that with two riders why were we issuing a mandamus to the
No, certainly.
honorable
My
speaker?
lord, your lordships fixed the time limit, and rightly, in case of 10 schedule, because speaker, right from Quixote Holohon, he is held to be a tribunal. He is not exercising, my lord, any
Tribunal
plenary.
amenable to the jurisdiction of High Court under 226, 227 and this court under
Absolutely.
136.
So, my lord, let me come to, my lord, page 168. I'll come to that judgment, my lord. That is one of the judgments relied upon by the other side. And therefore, I'm going to say that. Lord, as a matter of fact, and it would be interesting, I'll go in detail when I reach that stage. Lord, the parliament, my lord, amended the law that because judiciary is unable to do within a particular time limit.
Judiciary as well as the election commission.
No, not in
No,
that matter.
No,
Not in that, some other matter.
no, in Mr. Ashok Sen specifically says in his judgment that the proceedings before the judiciary and the election commission take so long.
No, I'm on a different judgment, but I'll read that.
Huh?
Symbol matter, my lords.
For election symbol.
No, I never want to touch on those
I
subjects.
think it was a cow and calf, and then I think they won the elections on Punjab.
Yes. Yes. The cow was, my lord, quite auspicious for them.
That's right.
We will not go into those issues.
Let's not go.
We'll restrict ourselves to the.
Comment for the.
No, and in any case, I am asking a wrong question my lord, now. My lord, page 168. Please have a look, my lord, this.
One?
168. My lord, the judgment. This is a 5-judge bench judgment. State of Bihar versus Kameshwar Singh. My lord, for two purposes I am relying upon. A, the governor is a part of the legislature and whatever function he exercises is quasi-legislative. The power of assent is quasi-legislative. And there are judgments on that, my lord, point. My lord, please come to, my lord, page 169. It's, my lord, my learned friend is right. It's legislative. Lord, 198, I have just highlighted. I am not right now saying this, my lord. I'll come to separately. The legislature of Madhya Pradesh consists of governor and the legislative assembly, but relevant is 235 at page 170.
Where you read this, sorry?
I'm sorry, my lord. Page 168, the judgment starts. It's state of Bihar versus Kameshwar Singh.
Para 198.
Okay, you quoted in the para. Okay.
Yes, it's quoted, my lord. It is
For a judge.
constitution bench.
Highlighted.
It's a 5-judge bench judgment. My lord, kindly see at 169. My lord, I'm at the foot. My lord, please come to page 168, para 20. Mr. Somaya's argument. Your lordship gets me? My lords get me.
Yes.
Mr. Somaya's argument based on clause 3 of article 31.
You are
which
at page,
ref-
page?
Page
168 bottom.
168
Bottom.
at the foot, my lord. State of Bihar versus Kameshwar Singh, para 20. Mr. Somaya's argument based on clause 3 of article 31, to which reference has been made earlier, is equally untenable. It is true that the legislature of the state includes the governor and that a bill passed by such legislature cannot become a law until, please mark, until it receives the governor's assent. Article 200, however, contemplates one of the 3 courses being adopted by the governor when a bill is presented to him after it is passed by the House or Houses of Legislature. 1, to give his assent, or to withhold assent, or 3, to reserve the bill for consideration of the President. Correct, my lords? The first proviso to that article deals with a situation where the governor is bound to give his assent and has no relevance here. The second proviso makes reservation compulsory, where the bill would, if it became law, derogate from the powers of the High Court, but such reservation, it is important to note, should be made without the governor himself having assent to the bill, giving assent to the bill. It is significant that the article does not contemplate the governor giving his assent, and thereafter, when the bill has become a full-fledged law, reserving it for the consideration of the President. Indeed, the governor is prohibited from giving his assent where such reservation by him is made compulsory. The Constitution would thus seem to contemplate only bills passed by the House, etc. Please come to 235 at page 170. Great.
How do you, the first proviso to that article deals with the situation where the governor is bound to give his assent.
If it is returned, that's what they say. Obviously, he cannot withhold, then he has to.
Yes.
My lord, he can withhold, or my lord, he can give assent, or he can even still refer. He can still refer. He may give an opportunity to the legislature.
So according to that is his choice. Either he can withhold
No, I'm
or send it to the, or return it to the legislative house.
No, my lord, I'm sorry, my lord. I'll again, my lord, make myself clear. He has 3 options in the main proviso. He can grant assent straight away. He can withhold, which according to me, the bill lapses or bill falls through, as Supreme Court says. And third option, refer it to the president. Fourth option, other than these three, is when he feels that there is some repugnancy somewhere or there is some tweaking required somewhere, then with his message, he will send it, he will return it to the House with a request to reconsider it. When the House reconsiders it, then the embargo is he cannot withhold, but he can still say that, all right, you have not considered my suggestion, you have not removed the repugnancy or whatever difficulty I have suggested. I now refer the matter to the president for his assent. That is not prohibited. Correct, Madam? Now please come to 235. Great stress is laid on the words law and the legislature of a state. It is stated that the clause postulates a law made by the legislature of a state. Reference is then made to Article 168, which provides that for every state there shall be a legislature which shall consist of the governor, and so far as Madhya Pradesh is concerned, of one house, that is Legislative Assembly. The argument is that Article 31(3) requires that a law must be reserved for the consideration of the president. If a bill passed by the assembly is reserved by the governor for consideration of the president without giving his own assent thereto, it cannot be said that a law is reserved for consideration of the president, for up to that state the bill remains a bill and has not been passed into law. Therefore, it is urged that after a bill is passed by the state assembly, the governor must assent to it so that the bill became law, and then that law to have effect must be reserved for consideration of the president. This admittedly not having been done, the provisions of Article 31(3) cannot be said to have been complied with, and therefore the act cannot have any effect at all. I am unable to accept this line of reasoning. For one thing, it assumes that a bill passed by the state assembly can become a law only by the assent of the governor. That is not so. Now please see. The procedure to be followed after a bill is passed by the state assembly is laid down in Article 200. Under that article, the governor can do one of three things, namely, he may declare that he assents to it, in which case the bill becomes a law, or he may declare that he withholds assent therefrom, in which case the bill falls through.
Falls through unless the procedure indicates.
Yes.
Is followed.
Falls through. So, if he does not choose, my lord, the option of proviso, the bill falls through. So, unless means that's the option. Either I withhold or I revert, I return the bill. Otherwise, it has no meaning. Falls through has no meaning. Therefore, unless is an exception, that if he withholds at the first instance, it falls through. Unless he resorts to the proviso, unless the procedure indicated in the proviso is followed, or he may declare that he reserves the bill for the consideration of the parliament, in which case the president will adopt the procedure laid down in Article 201. Under that article, the president shall declare either that he assents to the bill, in which case the bill will become law, or that he withholds assent therefrom, in which case the bill falls through, unless the procedure indicated in the proviso is followed. So, falls through has only one meaning.
Why is it combined with unless? The proviso.
Because it's an option given.
That's a completely separate, disjuncted and independent of falling through according to your
Correct,
reading.
my lords.
According
Correct.
to your reading, proviso is completely different to declaration.
Fourth option.
The fourth option.
So, my lord, what it says is, I'll put it, my lord, I rephrase myself. My lord, unless he exercises the fourth option,
Then there is no declaration of withholding.
that's my lord.
He cannot, the governor
But
cannot
that's where, my
on the
lord-
one hand declare that he is withholding,
That's exactly what I'm saying. my lord.
same time exercise
Correct.
option 4.
Correct, my lord. Therefore, I'm saying that he has to assent, withhold, or reserve unless he chooses the fourth option. Otherwise, one of the three options are complete in themselves. So therefore, my lord, my submission is that the proviso is an exception to first, second and third in the main part. He may not grant assent, he can return it. He may not withhold, he may return it. He may not reserve it for precedent, he may return it. But after returning, if it is passed, one option is taken away, he can either assent or.
Is it your argument, Mr. Solicitor, that if the governor exercises option number 2, that means withhold? If he exercise, let us say rather otherwise, if the governor decides to exercise the option 1, 3 or 4, then he cannot fall back on option number 2.
Yes,
Withhold.
yes.
But if he exercises option number 2 as the option number 1,
First
he
option.
still have the prerogative to exercise option number 4.
No, he cannot thereafter.
According to him,
Unless,
according to him, if the governor chooses to exercise option 2, withhold, the bill falls through.
will falls through, but then
Unless is the word used in the judgment, it's not in the
Prejudice.
article.
unless the procedure indicated in the proviso is followed.
Meaning thereby,
Beforehand.
meaning thereby, he can assent or follow the proviso. He can withhold or follow the proviso. He can reserve it for the precedent or follow the proviso. But if he withholds, there is no question of following the proviso. That is why it says, the proviso says, then you cannot withhold. Because then you have abandoned your right of withholding at the.
So there are in two ways you would look at second option of withholding. One is standalone withholding, that when at the commencement, governor says that I withhold, standalone, it will come to an end. There is no further adjudication.
That's my submission.
Second situation is where he seeks to withhold, but he will first resort to the proviso and then send it back. And after it comes back, he can't withhold.
He cannot.
That's what you're saying.
Yes. That out of 3, he says,
You're saying.
I'll not, yes. Out of
But
3,
your contention basically is that the standalone withholding and straight away tell him that I am not going to grant you any further will disentitle the governor from invoking the proviso second time.
I'm grateful.
But that takes you to the larger question of course, we will test this also.
But that's why we have.
Therefore, the question of judicial review becomes far more important. There your stand is there is no judicial review.
There is
That is
no,
the scary
I'm
part
not
of
saying
it.
there
That's
is
why-
no judicial.
that's why
the difficult part.
I'm sorry. I am saying it's not justiciable, and Supreme Court has said.
Same thing.
That's why
Supreme Court.
expressions,
Can't be
two
replaced.
expressions shall declare acquires lot of eminence and importance, because shall declare means that it's not a simple empty declaration. If you want to withhold, then that declaration must also assign brief reasons of withholding. Otherwise,
that
how to exercise the power of judicial review?
You have a.
My lord, your lordship, sir, my lord, I am yet to argue on judicial review and justiciability. My lord, there are several powers under the constitution where we are not, my lord, for example, precedent also, my lord.
Well, like, secondly, in the context we
Only-
are saying that if the second option is exercise withholding, that he withhold, and then he can't exercise the other options.
Yes,
If we are talking of,
other option of returning, yes.
Mr. Mehta,
if we are talking of the wider powers of the governor, then why this curtailment? Today, he decides to withhold it
Yes.
because he feels that this bill is completely extra constitutional. This is so and so. Then later on an advice, he feels that if with certain amendments, certain modifications, this bill can also pass the muster of the
Then he can,
constitutional.
he can,
Therefore, what prevents him to exercise option number 4 to return it with that message? And let us, how to read this curtailment of power under 2
in a fact situation, my lord, suppose he withholds,
Absolutely right. Tell you, because that's the political process, how it occurs.
that's exactly.
Not like a.
It's quite possible that the chief minister may go and say that, please don't withhold.
That the way political process occurs is not adjudicatory. where a decision is taken, it's nothing like a decision taken. Even assuming that the governor says that I withhold, again, political process can again knock on his door. He can still open it and say, okay, all right, I see a reason, then I'll send it back to you, reconsider, and then send it back. But to say that first time when he says I withhold, matter comes to an end, that can't be like that. It can't, because it's counterproductive to the powers of the governor, counterproductive to the legislative process also. So it has to be in a situation where it should be open-ended, that first he might say no. We see the point in what you are saying. If it is grossly a case falling directly under list one, he could say no, but he could also say, please modify it, rectify it.
Suppose the entire, suppose, my lord, take an example. Entire act is in list one.
But still, it can.
There is no question of returning it.
It may, but he can still say that, please look at it, because your whole act is falling under list one.
Kindly see.
Say, but to say that, don't go back again.
So, my lord, if a
Sir, on the ground of legislative competence, because it's
Lord, suppose, I'm sorry.
And the bold portion which you are just reading. The procedure to be followed after a bill is passed by the state assembly is laid down in Article 200. Under that article, the governor can do one of three things. Now, let us go one by one.
But it's not a statute, it's paraphrasing. Let's read it as a judgment. Yes.
It's a judgment by 5 judges.
No, it's a judgment, that's all.
Namely, he may declare that he assents to it, in which case the bill becomes a law. So
Correct.
this is first out of three, one. Or he may declare that he withholds assents therefrom,
Complete second.
in which case the bill falls through unless the procedure indicated in the proviso is followed. This is second. Then comes or, the third one. Or he may declare that he reserves the bill for the consideration of the president, in which case the president will adopt the procedure laid down in Article 201. So these three situations are contemplated to be taken up by the governor once the legislature passes a bill and sends it to him. Correct? So now this, unless proviso is invoked, is coupled with withholding the assent.
The difficulty is, my lord, the Supreme Court here is paraphrasing 200 and we are reading instead of 200.
This is not paraphrasing, this is interpreting 200.
No, it unless is a separate option. Textually also it is a separate option.
Therefore, we had asked that
I'm
question
only-
earlier,
I am on.
whether withholding would mean that he withholds and he exercises the
Cannot-
proviso.
Kindly give.
That is what this judgment says.
Otherwise, in which case the bill falls through has no meaning. Number one. Number two, Lord, suppose. Lord, kindly.
No, he may withhold it, declare it and not refer it under the proviso.
Correct. Certain.
Then it will fall through.
Correct.
But at the same time of withholding,
He can.
invoke the proviso also.
It's a possible. Lord, kindly appreciate. But that depends upon the facts. Lord, suppose a state legislature were to pass a law.
Just trying to understand what this, the language used in this judgment, what does this ultimately reflect and how do we interpret it?
Correct. Your lordships are also in the 5 judges.
Yes.
I'm not on that, my lords. My lord, please appreciate, my lord, to take example of a state, my lord, where the legislative assembly, for good reason, because of the, my lord, feelings in the state, passes a law that we will not enter into any trade or commerce with a particular foreign country. The trade or business is in the second schedule. There is no question of, my lord, repugnancy, but it ultimately, my lord, is the subject of external affairs, my lord, with the country. The president may say that, no, you can't do this. There are several examples, my lord, which we can give, where something is so abnormal that president will have to say that withhold. I can't, my lord, suppose a bill is passed, my lord, regarding defense of the country. My lord, he will have to withhold. He can't return it to the house because his decision to withhold is based on the premise that you did not have the competence to do this. So then, my lord, Raja, my lord, Bhairendra Narayan
In
Bhup,
any case, the Kameswar would be with regard to protection under 31A and 31B.
Ah.
The question with regard to 200,
no, so 200 is, my lord, examined.
It's only going.
200 is examined. This is precisely, that was the question which fell for consideration, and it is, my lord, if we want to find out a distinction, there can be other distinctions.
no, because every judgment has to be read in the facts, in the context of the facts.
I bow down, my lord, to that proposition. There cannot be any difficulty, my lord.
Because the main argument appears to be,
It was a different context in the sense that it is answering a question, saying that it becomes automatically law. He says in reply, saying it doesn't become automatically law unless it is assented by the government. In that context, it was said.
My lord, Raja Bhairavendra Bhup, my lord, was under the Government of India Act, but the same words I have already pointed out to your lordships, my lord, are used. Please see. Dealt with the constitutional validity of Assam State Acquisition of Zamindari Act and whether it was within the competence of the state legislature in the peculiar facts, etc. My lord, please turn the page over. Broadly speaking, it may be said that a bill begins to pend with its introduction in the legislative chamber and it ceases to pend, A, when it lapses under section 73(4), B, when the governor declares that he assents in his majesty's name to the bill, in which case the bill ripens into an act, or C, when the governor declares that he withholds his assent therefrom, in which case the bill falls through, or when being reserved by the governor for the consideration of the governor general acting under section 76 declare that he assents in his majesty's name to the bill, in which case also the bill becomes an act, or when having been so reserved by the governor general declares that he withholds his assent therefrom, in which case again the bill falls through. F, when the bill having been reserved by the Governor General for the signification of his Majesty's pleasure thereon under section 76(1), the Governor under section 76(2) makes known by public notification that his Majesty has assented thereto, in which case again the bill becomes an act, and lastly, when no such notification is issued by the Governor within 12 months from the date on which it was presented, in which event also the bill comes to an end. Lord, because there was a time limit, otherwise it would lapse. In short, a bill may be said to be pending as long as it does not lapse or it does not become an act by receiving the assent by the appropriate authority, or is not terminated by withholding of assent by such authority. Withholding has been given this meaning and this meaning only. It's a complete event, my lord. Once the governor says, I withhold, lord, if that is not a wise thing, then it is for the parliament to amend. But this is how judicially it has been interpreted. The contention of the appellant is that when the bill under... Yes, my lord. Now please see my lord, page 173, Purushottam Nambudri. My lord, again, a 5-judge bench judgment. My lord, what I read was also a 5-judge bench judgment.
Yes.
Then Valluri, Basavaiya Chaudhary, my lord, I have, my lord, cited at 2 places, but I'll read it at page 173. One was cited to say that it is a legislative act. Grant of assent is a legislative act. And therefore, my lord, I would, my lord, come to that submission that there is no principles of natural justice or reasons, etc. It's a legislative act. It's a plenary constitutional power to be exercised by a high constitutional authority whose my lord, wisdom or bona fides are not to be doubted. Lord, please see at at the foot, my lord, 173, it is submitted that Union of India versus Valluri Basavaiya Chaudhary. My lord, it's again a 5-judge bench judgment, my lord. My lord, none of these judgments are cited in Punjab, state of Punjab versus Union of India. 3-judge bench. Not even referred to.
And in Tamil Nadu?
The Tamil Nadu refers, but I'll show, my lord, how it says they are, they rely, Tamil Nadu relies on Punjab and say that these are per incurium or something. I'll come to
Per
that.
incurium. How can 2 judges say that 5 judges bench are per incurium?
My lord,
Pavitra, it says it's for.
my lord, there is one,
Pavitra is factual.
Pavitra is, my lord, a 2-judge bench judgment,
Yes.
where
Pavitra is-
all this is considered, and Tamil Nadu says,
Pavitra 1 or Pavitra 2?
Pavitra 2. Pavitra 2. My lord, it follows 7-judge bench of Samsher Singh. And the,
Pavitra 2 was with regard to reservation.
correct, my lord, but it was reserved for the precedent, and this question squarely arose about the justiciability, etc.
Well, I think one of the Pavitras was two judges.
Both are 2 judges. The one which is declared per incurium is by Justice,
I was part to that bench.
no, my lords were not, the, what is,
I have held Pavitra to be per incurium in some matter.
That is in Journal Singh with Justice.
but that is on the question of reservation.
On the reservation.
On the reservation. My lords were sitting with Justice
Vishwa Rao.
Nageshwar Rao and Justice Khanna
That's correct. That's
in, my lord,
Journal Singh.
Jarnail Singh. But that is on a different point, but that's on
the reservation of
reservation,
reservation. yes.
not on this 200. Here, my lord, Pavitra, this question squarely arose. Pavitra refers,
Quantifiable data.
yes, my lord, yeah.
On the issue of quantifiable data. So
Correct, correct. Quantifiable data and designated commission, etc. But that was a separate issue, my lord, that we are not concerned. Here, my lord, Pavitra dealt with Article 200 and 201 with these judgments, 2-judge bench judgment, my lord, Justice Chandrachud and Justice Lalit, which is declared to be per incurium and relying upon, my lord, Punjab in Tamil Nadu case, my lord. But now see, Union of India.
Surprised when you said that the Tamil Nadu judgment says that the constitution benches are per incurium.
only on one point. Mala.
On one point, I'll read that.
That's it.
I'll read that. I'm not criticizing the judgment, my lord. I'll read what is written, my lord. I can't improve upon it. I can neither improve upon the text of the law or the judgment, my lord. I can only place it. My lord, Union of India versus Valluri Basavaiya Chaudhary, again, my lord, 5-judge, not cited in Punjab. The governor is, however, made a component part of the legislature of the state under Article 168 because every bill passed by the state legislature has to be reserved for the assent under Article 200. Under that article, the governor can adopt one of the 3 courses, namely, he may give his assent to it, in which case a bill becomes a law. 2, he may, except in case of a money bill, withhold assent therefrom, in which case the bill falls through unless.
Again, unless is added here.
Correct.
It's the same language as.
Correct, my lord. It is an exception to 1, 2, and 3. I have no difficulty, but it's not an exception to 2.
But,
And-
there is no direct judgment so far which holds that the governor has the power to withhold the bill permanently.
My lord, I have read, my lord, one judgment. It says it falls through.
No, but both the judgments, it falls through.
No,
No, that judgment which you are relying,
whoop, whoop.
no, it doesn't consider 200, it considers the Government of India Act of 1935.
Same identical, perimaterial.
Wherein timelines are also provided.
Timeline has no, my lord, relevance.
Timeline, according to the time, so all on the timelines. The 1935 Act provided no timeline.
I'm sorry, my lord, I'm sorry. Yeah, it can be distinguished on other ground. Timeline is
No,
a separate issue.
The text of 200 may be paramateria to 73, 74 of the 1935 Act.
Correct, my
But
lord.
there is a slight distinction. It's not as, the words are not 100% imported from the 1935 Act.
I'll, my lord, show the show, my lord, the,
So-
both the provisions.
so-
Lord,
so-
timeline is the seventh option, that if it's not done within 12 months, then it lapses. That's the only addition, my lord, there is no change. My lord, as a matter of fact, Government of India Act, which is considered, had no timelines. But even if, my lord, there is a timeline, it is a last option, that then it lapses. It's an option of the legislature. My lord, please see page 143 is that provision. Page 143.
Page one.
143. My lord, your lordships have read it, my lord. The 143, my lord, the 75 of Government of India. Perimeteria provision, my lords. And there was no timeline stipulated. The court says that if it is returned by the president, I'm sorry, my lord, the Chief Justice is reading.
Have a provision in his discretion. 35 Act. In his discretion.
Where are you reading?
Have a look.
I know, I have highlighted it. You possibly missed when I was arguing. Yes.
Difference.
My lord, I can have a discretion of A, B, C.
Correct.
Correct, my lord? One provision. Second provision says that I may do A, B, C. So the word discretion being taken away.
Judgments which we've been reading just now, they club your may with two.
No, no, my lord. I'm saying something else. I'm on a discretion that the word
No, you are replying to Mr. Sibal.
Yes.
You address the court, why you have to reply to him?
I'm responding to his interjection, my lord, which was out of context. There.
No, because in that Raja Bhairav Indra Narayan book,
Yes.
there is also a reference to section 73(4) of the Government of India Act. So we don't have that section 73(4) here.
We do, but it says it should be.
In the notes, it is not here.
No, no, only Mr. Sibal,
Dr. Singh is back.
This has been in and out many times.
Yes.
I've been tracking and I'll be there well before my turn comes.
No, he
Well,
tracks every court, not only this court. He tracks every court.
as I don't get all the accommodation he gets in Passovers.
No, no, he tracks every court.
There appears to be some different scheme under the
No, no,
1935 Act.
let me show, my lord, that scheme.
What is over
I'm there, Mr. Sibal. You can rest assured.
PDF 382. No, you just said it's the same, therefore I was, okay.
निकाल लेना volume को.
PDF 382. And now this logic, you know, just as an aside, if you apply this to 111 of the Constitution, if the Parliament passes a bill, the President of India can withhold it, and it lapses. The same logic will apply to 111.
Why are you angry? If
No,
that
but
is so,
then-
that is so.
No, but then he distinguishes that,
About it. That's the
that,
constitution.
his answer to that is that the president has no discretion.
He has.
Whereas the governor has a discretion.
How can he have?
He has.
when-
That's the scheme.
If the language of 111 is he can give consent or withhold consent. Just see 111.
Lord, but precedent
Which
is
means when the
supposed.
president, if Parliament passes a law, he can withhold dissent. How can that be accepted as a constitutional principle?
It's too general a proposition. How can something be accepted as a proposition? So that is the constitutional provision. Precedent is bound by aid and advice.
Let us
There is no
understand,
option.
let us understand the plain language of the constitutional provision instead of the consequences.
Correct.
Consequences will come later on. First, let us understand this part. I think problem is that probably two constitutional bench judgments say the way.
No, there are further. But can I complete the judgment?
Okay, yes. But the scheme under the old 74 and 200 appears to be somewhat different.
No, no, my lord, kindly.
75 also.
No, let Mr. Sibal, my lord.
No, I'm just pointing out the page. PDF.
No, you are saying that there are no timelines. If you read 74,
I,
74(2), there is a specific timeline of 12 months.
having a timeline has no relevance with this part of the judgment. That's what I'm saying. Okay, can I, my lord, again read it? Let us again.
So therefore,
But can I
When,
read?
when we interpret 200, we will be more guided by Kameshwar and Valluri Baswaya than that Bhairava,
Can I read?
that Raja Bhairavendra.
Oh, Lord, can I remove that impression of timeline affecting the?
No, but when we have judgments directly on 200, why should we go on a judgment of a British Act? You yourself argue that we have interpreted Indian law, so why should we go to the American and
It's not American, it's an Indian law.
the 74 Government of India Act?
No, it's a Supreme, your lordship's judgment.
But now we have our own constitution.
Who is your lordship's
Because
judgment?
our judgment interpreting 74.
I can't argue, my lord, if your lordships are a respondent.
No, it's our judgment interpreting 74.
Correct, my
But
lord.
when we have direct judgments interpreting 200 of our constitution, why should we go to the interpretation on 74?
Scheme is same, number is different.
Even we are saying prima facie, it doesn't appear to be identical.
Therefore, my lord, that prima facie impression, can I?
Then why don't we restrict ourselves to the interpretation of 200? When there are judgments on interpretation of 200,
Can I, my lord, remove that prima facie impression?
yes.
Kindly have a look at section 74. Subject to the provisions of this section, a bill shall not be deemed to have been passed by the chambers of the legislature of a province having a legislative council unless it has been agreed by both. My lord, we are not concerned. Then your lordships may kindly come to 75. My lord, 75 is relevant. My lord, at page 383. The court is on.
383,
My lord, if your lordship.
volume 4.1.
Section reading. It's same, my lord.
Read it.
73, my lord.
Yes, we are
Section 75.
Both discussion.
My lord, I would request Mr. Sibal, my lord, to. These are prima facie observations. Neither I should feel discouraged, nor.
No. We are hearing you, but since we should understand the subject, therefore we must know.
Exactly. I am just, my lord, requesting Mr. Sibal not to be happy. It's little too early to be happy. That's all I'm saying. Whereas
Then there is no question of one being happy or unhappy. You do your duties, we do our duties.
We are
That's all.
capable of making him happy and you happy both. Don't
But here it's a presidential reference. Nobody wins or loses.
Yes.
75. This was more on interjection by him, not on the court asking questions. Obviously, we are bound to answer. A bill which has been passed by the provincial legislative assembly or in case of a province having a legislative council, we read state, that was the only, has been passed by both the chambers of the provincial legislature shall be presented to the governor, and the governor in his discretion, my learned friend would again interject and say there was a discretion. There is none in 200. I am conscious of that. Discretion shall declare either that he assents in his majesty's name to the bill, or that he withholds assent therefrom, or that he reserves the bill for the consideration of the governor general, provided that the governor may in his discretion return the bill here together with message requesting that the chamber or chambers will reconsider the bill or any specified provisions thereof, and in particular will consider the desirability of introducing any such amendment as he may recommend in his message, and when a bill is so returned, the chamber or chambers shall reconsider it accordingly. Correct, my lord? 76 is 201, my lord, if he refers. So, my lord, it is the same
thing. Exactly.
the time limit. I'm just, my lord, trying to, my lord, address my lord's right query that there was a time limit, but that has nothing to do with the interpretation of 74 and 70.
The 74 appears to be analogous to 196 in the present constitution.
I have not checked up that.
We are just trying to compare.
Yes, possibly. 196 and 197 possibly, I'm told.
Yes, now let us see. You are
Now,
saying that there are many more judgments, so we go to them.
yes. Lord, now haste. Lord, here only one addition which the Supreme Court makes is with regard to money bill, which is not provided in the first part of Article 200. President cannot withhold money bill. A, conventionally, money bill is never to be withheld. Hope everything is fine.
Yes, yes.
So now there is a three-judge bench judgment of haste.
Yes, yes.
A haste or my lord, haste, my lord. Not here money bill because this might be my lord, distinction without any difference or difference without any distinction. There is a money bill issue, but we are not concerned because money bill conventionally can never be withhold. And number two, under the Constitution, Article 2074, please bear in mind, money bill is always introduced on recommendation of the governor. So there is no question of is withholding. Now, in this context, please, my lord, see para 85. The constitutional position of a governor is clearly defined. The governor is made a component part of the legislature of a state under Article 168 because every bill passed by the state legislature has to be reserved for assent of the governor under Article 200. Under that article, the governor can adopt one of the three courses, namely, one, he may give his assent to it, in which case the bill becomes a law, or two, he may accept in the case of a money bill, withhold his assent therefrom, in which case bill falls through unless the procedure indicated in the first proviso is followed at his option, either withhold or return, my lord.
That doesn't appear to be the plain reading of that sentence.
That's my contention. That's how I interpret it. Unless otherwise will have no meaning. And falls through will have no meaning at all. Or every judgment uses the word, if he withholds, it falls through. But again, please examine from one angle and please remove for the time being that impression.
Which we are not there.
I'm sorry.
We are not gathered any impressions so far. We are.
No. That why unless is to that impression, unless is to be read. But the meaning of the word falls through means.
We quite understand
Another,
that you want to distinguish a situation where he withholds or where he decides to return it to the assembly. Then in that case, his power to withhold will be temporary. And if the legislature on the second occasion decides to go by the bill, then he will have to grant assent.
Go by the bill with or without modification, even
Yes,
if.
he will be bound. But when he exercises his powers only to withhold, then he can do it absolutely.
I'm great.
We appreciate this.
Whether your lordship accepts or not, this is what
That is your argument. So
that's my submission.
so your argument is rightly registered by us.
Pardon?
Is rightly registered by us.
No, registered.
Yes, registered. Yes.
Yes, your lordships have rightly registered my argument. Ball will falls through unless the procedure indicated in the first proviso is followed, that is returned to the bill to the assembly for consideration with a message, or he may, on the advice of Council of Ministers, reserve the bill for consideration of the President, in which case the President will adopt the procedure laid down in article. Lord, now kindly see, my lord, the incongruity which will arise. Lord, suppose the governor is supposed to act on the aid and advice of the Council of Ministers generally, unless, my lord, the question of withholding comes. Why I say this? No Council of Minister would say that my assembly has passed a bill, you please withhold it. My assembly has passed a bill. There are circumstances where the ministry would advise that you refer it to the president. And I'll tell your lordships why. There are certain provisions which I will show where presidential assent is mandatory. It is not at the discretion of the governor. And therefore, it will be in the interest of the ministry, the council of ministers, to advise the governor that you please take assent of the president. Otherwise, my lord, for withholding of the bill, there would not be any question. And unless, my lord, that is read as a discretion conferred upon the government, my lord, upon the governor, my lord, there are several situations, my lord, I'll come to, which will not be able to, my lord, reconcile with the constitutional scheme. Even the ministries, the council of ministers can request him to withhold. Lord, please take pre-10th schedule scenario where there was no whip. Correct, Manoj? There is a council of ministers consisting of 15 people. They lose majority and a bill is passed in the house which is not of the liking of the council of ministers. There was no 10th schedule, my lord, prior to 84. And we are dealing with Article 200, which is since 47. Maybe the council may advise him to withhold, saying that this is, I am not agreeing to this. And he may, in his discretion, can still say that no, it is passed by majority in the house. You may not enjoy confidence of the house, but it is passed by the house. I will grant assent. Or he may, in his wisdom, call the chief ministers and say that I am returning it to the house. You go and convince your people. That is where, my lord, his statesmanship comes. Lord, what we are, my lord, undertaking an exercise is that a rogue governor would act in this particular fashion, and therefore we have to interpret in such a manner that he cannot act in this fashion. Therefore, my lord, I am repeatedly requesting the honorable court, and my arguments are molded accordingly, that consider an ideal situation and interpret. Lord, keep possibility of abuse in mind.
No,
But-
we quite appreciate your submission that when a power is vested with a high constitutional functionary, it is to be presumed that the power will be exercised properly and in a bona fide manner. And we can't proceed on a presumption that the power would be
Everybody
exercised
would misuse, or in all cases it would be misused.
or an possibility of the misuse of power cannot be a ground to challenge the validity of a power.
Or even interpret it differently, my lord, if the intention is very clear.
Don't be under the impression that we are asking because of the prejudice in the way the governors are acting. That has got nothing.
No, I'm very
Testing
confident.
the proposition. That's
My lord, it is that confidence, my lord, with which we have come before your lordships, that please advise us.
You are also not aware about
How the
governors are acting.
Yes. There are several situations, my lord. These are all political issues. And, my lord, I'll come to that as a legal proposition.
So therefore, at least I always say that let this not be a battleground for political. We will decide, we'll interpret the constitution as it has to be
And, my
interpreted.
lord, there are several issues where the solution lies elsewhere. Every problem need not be and cannot be solved by the third, my lord, one of the organs, namely the judicial.
Third chamber.
No,
Like Pandit Jawaharlal Nehru, while introducing 31A and 31B, they said that when we determine the compensation in order to advance the social and economic justice,
court will not go into it.
we expect that the Supreme Court and the High Courts would not act as a third chamber.
Third chamber, yes. No, in fact, thereafter it was prohibited also that the court cannot go into
Yes,
it.
but then that has been set aside. That those amendments have been set aside not once but twice.
The executive or legislature has never been permitted to encroach upon the third organ of the state. I leave it at that.
You want us to comment on that? No.
No. No, Manoj. My statement was like withhold complete.
In spite of Keshav and Bharti, those two provisions, in Article 13 and 368 were again sought to be reintroduced, and they were again set aside.
Yes. So, my lord, therefore, my lord, I say that executive and legislature has never been permitted to encroach upon the judiciary.
No comments from this side.
Yes. There is one judgment on that, my lord. There is one judgment on that. I am going to rely upon it, my lord, on justiciability. Now, my lord, please come to, my lord, State of Punjab versus Governor of Punjab. My lord, this is that three-judge judgment, three-judge bench judgment, my lord. My lord, please mark, please note the judgments which I read before your lordships
They are not noticed by this bench.
is not noted. My lord,
Either not brought to the notice or not noticed. So
either way, my lord, it's correct.
your argument would be this is per incurrium those constitution bench judgment.
It could have said that it does not mean what I am contending, but I didn't appear, but I'm just hypothetical, whoever appeared. It could have said that these judgments do not apply, or it applies in a fact, but nothing, my lord, it's in ignorance of those judgments. My lord, kindly see para 20 at page 175. The present case turn upon, I'm sorry. Lord, I'm on page 175.
Yes. Punjab.
Punjab, my lord, Justice Narsima is writing.
Punjab, yes.
No, I'll start after your lordship finishes the taking.
Go ahead, go ahead.
Para 20. The present case turn upon how the first proviso is to be construed. In construing the first proviso, it needs to be noted that the substantive part of Article 200 provides the governor with three options: an option to assent, an option to withhold assent, and an option to reserve the bill for consideration of the president. The first proviso opens with the expression, the governor may, in contrast to the second proviso, which begins with the expression, the governor shall not assent. The may in the first proviso is because the first proviso follows the substantive part, which contains three options for the governor. The first proviso does not qualify the first option, where the governor assents to the bill, nor the third option, reserving the bill for consideration of the president. Please pause here for a minute. Lord, I am putting a question to myself. Why? The governor may say that there is repugnancy. I am sending the bill back. The bill may be passed without modification, with slight modification. The governor may still feel that the repugnancy continues, and I will now refer it to the president. What is prevented is he cannot withhold, not that he cannot thereafter refer it to the president. On the textual, on the only available interpretation or reading of Article 200 contains the first proviso does not qualify the first option, where the governor assents to the bill, nor the third option, reserving bill for the consideration of the president. The first proviso attaches to the second option, withholding of assent, and hence begins with an enabling expression may. By the mandate of the second proviso, in fact, if it would have said shall, then this finding would have been right. May, by the mandate of the second proviso, there is an embargo on the governor assenting to a bill which derogates from the powers of the High Court under the Constitution. The governor is, by the mandate of the Constitution, required to reserve such a bill for consideration of the president, that is High Court's power, etc. A proviso, as is well settled, may fulfill the purpose of being an exception. Lord, kindly pause here for a minute. Series of judgments that proviso is, unless context otherwise requires, is an exception to the main provision. Sometimes, however, a proviso may be in the form of an explanation or in addition to the substantive provision of a statute. But this is fourth option. The court says it is only a limb of the second option. The first proviso allows the governor, where the bill is not a money bill to send it back to the legislature together with a message. In terms of the message, the legislature may be requested by the governor to reconsider the entirety of the bill. This may happen, for instance, where the governor believes that the entire bill suffers from an infirmity. Lord, kindly pause here for a minute. This again is wrong, with profound respect. He can refer for several reasons. In entirety, bill may not be partly
That's what they send the next sentence. Sometimes we may feel that the entire bill suffers from illegality. Sometimes the governor may feel that a part of the bill is not in accordance with law, and therefore he may refer part of the bill for reconsideration.
Exactly. No, but here it's but the governor believes that the entire bill suffers from infirmity. Alternatively, the government may request the legislature to reconsider any specific provision of the bill. While returning the bill, the governor may express the desirability of introducing an amendment in the bill. The desirability of an amendment may arise with a view to cure an infirmity or deficiency in the bill. This again is wrong. The governor may say that instead, for example, it's an age limit, that instead of 25, make it 21, or instead of 21, make it 25. This is my suggestion. This is my recommendation. Desirability means not legality or constitutionality. Desirability means something which the governor wants to add. The concluding part of the first proviso, however, stipulates that if the bill is passed again by the legislature, either with or without amendments, the governor shall not withhold assent therefrom upon presentation. The concluding phrase, shall not withhold assent therefrom, is a clear indicator that the exercise of the power under the first proviso is relatable to the withholding of the assent by the governor to the bill in the first instance. That is why, in the concluding part, the first proviso indicates that upon the passing of the bill by the legislature, either with or without amendments, the governor shall not withhold assent. The role which is ascribed by the first proviso to the governor is recommendatory in nature, and it does not bind the state legislature. The substantive part of Article 200 empowers the governor to withhold assent to the bill. In such an event, the governor must mandatorily follow the course of action which is indicated in the first proviso of coming to the state legislature as soon as possible. Lord, question of withholding and return, my lord, would come. Lord, what is withhold? That I do not grant assent, I do not refer it, I withhold. Lord, now the way in which this is read, please, my lord, see, this is a nuanced thing. If this finding is to be right, the wording of the proviso should have ended, governor after reconsideration and return to him will assent the bill. Kindly read it again. The substantive part of Article 200 empowers the governor to withhold assent to the bill. In such an event, the governor must mandatorily follow the course of action which is indicated in the first proviso of communicating to the state legislature as soon as possible a message warranting reconsideration of the bill. The expression as soon as possible is significant. It conveys a constitutional imperative of expedition. Failure to take a call and keeping a bill duly passed for indeterminate period is a course of action inconsistent with that expression. But that expression is used only when the fourth option is being used. I do not say that it can be held up indeterminate. That's not the contention. But as soon as possible is fourth option, and that expression is available only in the first proviso, not in the first part. For various reasons, before assenting, the governor may give some time for the situation to cool down. There may be a hasty legislation. The Constitution has said that there may be some hasty legislation because of some emotions of the people. He might want the matter to calm down. He might be in consultation with the chief minister, etc., etc. So the time limit being absent in the main provision is conscious. But if you want to return it back, you do it as soon as possible. And as soon as possible is,
According to you, with regard to withholding, there are two options possible. One, permanently withholding, and secondly, temporarily withholding when he wants to exercise the powers
no,
under the proviso. So when he
no, my lord, my submission is
Withholding means
assent, first option. Unless he returns
yes,
before granting assent. Withhold, second option. And if he exercises that option, he cannot withhold it if it comes back. Therefore, no return. And third, reference to the precedent. And after, if he exercises the fourth option of returning it to the House, and the House reconsiders with or without modifications,
then he is bound by it.
he is bound by it. Bound by it, my lord, so far as withholding is concerned, but he can still refer it for presidential assent, because that is not prohibited. He may say that there is repugnancy, but I don't wish to straightaway directly send it to the president. I return it to the House with a message that this section is repugnant. The House, in its wisdom, says, no, it is not repugnant. But the governor can still say that I think I need presidential assent, and he can send it.
Again, we are seeking clarification, Mr. Solicitor. According to you, if the fourth option is to be exercised, namely returning to the House with a message for reconsideration, only if option number 2 is also noted.
Grateful.
This is what you want to.
I'm grateful.
In other words, according to you, if it has been withheld, then option number 3 and 4 are defunct. Is it your argument?
Yes, it comes to that. Yes, correct. Yeah, different. Exactly, it falls through.
Let's be very clear in.
The lordships are right, my lord. That's, my lords have rightly understood my submission, but I'm grateful.
And for that purpose is that two judges benches which have used the expression, unless the governor decides to return it to the, according to you, that
Is that-
unless expression means that if he withhold, then there is no question of it.
Grateful, I'm grateful.
But probably you are trying.
I'm grateful. My lord, whether that finds favor with your lordships or not,
That's a different.
my lord, that's
We should understand that.
that's the satisfaction of a lawyer, my lord, when we can communicate what is.
Made solicitor that words beginning from unless
I think that.
have to be referred to the fourth option. Are referable to the fourth option and
Yes.
not to the second option.
Yes.
Fourth option, provided that second option is not.
why is the fourth option being placed as a proviso? And why not in the main? Why did they need a proviso for that?
No,
If that was a separate independent exercise or one of the four, routes which the governor could follow. One is accept, two is
know.
withhold, three is refer to the president, and fourth is to return back to the house.
I'll show, my lord. If
Why proviso for that? The
I-
fourth could have been a part of the main.
I'll
provision.
answer that.
That proviso,
My lord, there are two answers. If the way in which it is being read here, how Article 200 would have been worded, I have shown. And perhaps it is maintained in the proviso because historically it was always a proviso.
then according to you, the constitutional benches of 1952 and 56 have not correctly interpreted the Article 200 and the proviso.
No, my lord, I am relying upon that.
He is relying on that. He says that
I am relying upon.
that word
What
beginning from unless has to be referable to only to the proviso.
No, unless it's attached to withholding.
No, my lord.
Yes.
It cannot be. For,
Therefore, that has been wrongly decided.
you can say, I mean, rather than conveying through.
What you are putting to us, why does the word unless in the judgment appear after withholding of assent?
Yes, as the second option for the government. We need to be very clear as to what is your submission and what the constitutional benches have decided.
But the reason the word unless appears relatable to withholding is this, that when an assent is given, there is no question of a bill falling.
Correct.
When a bill is reserved or sent to the president, there is no question of a bill falling. The consequence of a bill falling only arises when under Article 200, the governor declares that he is withholding assent. It is in that context that the judgment says that the bill falls through unless you send it to the assembly. Doesn't mean it becomes an adjunct of
Second option.
of withholding. It is still an independent option. The reason in the Constitution when judgment unless appears is because either when the assent is given or it is sent to the president, there is no question of a bill falling. In this case, there is a case of a bill falling. It finishes the bill. That is why they say it will not finish if you exercise the fourth option and send. And historically, my lords,
Then the second option is not even exercised. If it is referred under the proviso, where is the question of the governor declaring that it has withheld the assent?
sent to the power, to the
Then there is no withholding by the governor.
legislature, not for a setback.
Correct. Then there is no withholding.
Historically,
After withholding, can the governor send it?
declares a withholding.
Correct.
The bill falls.
Right. And that's the end of it. No proviso, no precedent, nothing.
But he has an option of sending rather than withholding.
Sent to the legislative assembly. Well, please take it that historically from the Government of India Act of 1990, 1930, always the fourth option was there. Now, whether it was in the proviso or in the main part of the provision is a different issue. But the fourth option has always been there of sending it back to the legislative assembly. The learned solicitor will show that to your lordships. The option of sending it to the legislative assembly or parliament is a fourth option always.
Yes, Mr. Kaul, then I think probably you are adding a little more confusion to it. Now you say option is always there. The point was which we are trying to get the clarification in. This provided, this option 4, can it be exercised after option number 2 has been exercised? This is what we are asking you the question.
No, it cannot.
For the simple reason.
Therefore, according to you, the power under proviso is subject to option number 2.
Subject to, it's an independent option to be sent to the legislative assembly. But
If it is independent, then how are you making dependent on option 2?
The constitution benches have made it.
Wording is the language.
Constitution benches have made, guard out that.
Benches have said is what? Constitution benches have said. Firstly, what the options given are in the main body are either shall declare an assent, shall withhold, or reserve it for the president. Proviso is the fourth option, has always been the fourth option. The Constitution bench judgments also says can reserve it for the president, can assent, can withhold assent, and the bill will fall. But it will not fall if it is sent to the legislative assembly. And I'll tell you, lordships.
That's the whole thing. Then there is no withholding.
May I say with respect, may I?
Proviso applies
There is a
to first
declaration.
and third option.
For withholding also, there has to be a declaration.
Is concerned. Why it can't be linked to withholding? I'll give an example to you. A governor may be inclined to give assent, for bill, may be largely in agreement with the bill, but may feel certain tweaking, modification, etc. has to take place because it's ultimately part of a legislative process. This function of the governor is part of a legislative process. The heading of the part in the Constitution is legislative procedure, where Article 196 begins and then goes on to 200. It's part of the legislative process that your lordships have. Now, therein he may feel that some tweaking is required. So he sends it back for certain modifications. Even before the assent, he may be inclined to assent. Now, a situation may arise where he may feel that yes, it needs to be referred to a president. Yet he may feel that before it goes to the president, whether on issue of repugnancy, constitutional concerns or anything else, we may need some tweaking or modification or a consultative process with the legislative assembly, and I may then send it to the president. So it can't be said that the fourth option is only related to the withholding. That is not the idea. Withholding.
If you read it again, the intention is that withholding could be permanent or it could be temporary.
Present.
And temporary would be when proviso would be exercised along with withholding. And after that, when it comes back, either if it is reiterated, then he has with or without amendment, then he has no option but to grant the assent. Correct?
Refer to the president, but he cannot withhold.
He cannot withhold it.
Withhold,
Thereafter.
yes.
Correct. So therefore, till that time it is withheld when when proviso is not exercised. Yes. Therefore, if the governor declares that he is withholding the assent, the bill, then it falls permanently. The proviso is not exercised by him. Shall declare withheld. And he can declare it to withhold along with exercise of the proviso.
Send it back. We just send it back.
Why? Then if he sends it back, then he's bound by whatever this is the second time.
Comes back, he cannot withhold.
Then he has,
So therefore,
Then he has two choices.
solicitor's argument is that, as we understand, that withholding and exercising the power under proviso are two different things.
correct, Manoj.
If he decides to withhold, he may decide to withhold at the threshold.
Exactly.
And only in case, if he finds that reconsideration necessary, then the recourse will be taken to the proviso.
Instead of withholding, he will exercise the option of.
So
sending
that will be not an exercise of withholding, but referring it to the legislature for reconsideration.
Could be applicable to first and third option.
Just say, if I may, it's the crux. Instead of withholding,
Right away. Right away.
right away, send it.
No, then your argument is contrary to what the learned solicitor is arguing.
Just keeping it as the fourth option. The fourth option of returning it as part of a legislative process and a procedure as a consultative process with the.
No, you are saying that withholding and in the meantime sending it back.
Instead of withholding, I said.
So you said,
I said, that is what I thought fell also from my law. Instead of withholding. Withholding is one option. Assent is the second option. Reference to the president is the third option.
That is why the expression which says instead of, it gets color, provided that the governor may as soon as possible after the presentation of the bill return.
Return, sir.
As soon as possible. Instead of withholding, has a doubt about it's.
As your lordships rightly said, the words used in the proviso are after the presentation to him of the bill for assent, not withholding of assent. It says after, as soon as possible after.
Are also arguing that if the power to withhold has been exercised, then option number 2 and 3 becomes defunct.
Right.
Not left with power number
1 and 3. Withhold is 2.
holding is 2,
Two.
so that means 3 and 4.
1,
One in any case goes.
1, 3 and 4. Yes,
One, see, one is not there.
obviously.
Assent is not there, that's
My
why
lords are
two.
right. My lords
So
are right.
once the governor exercise option number 2,
Yes.
then option number 3 and 4 become defunct. This
Because, my lords, the bill falls through as we are seeing the judgment. If the bill falls through, then how is it kept alive?
Brother correctly said it.
we are interpreting a constitutional provision which will lead to rendering two provisions, if not fully, partially defunct.
No, my
No,
lord.
no, no, my lord.
No.
It would be contrary.
No.
That is our submission.
My lord, there are three options if they are available, and one option is exercised. Because of exercise of that one option, if the other two options become unavailable, there is nothing wrong with that constitutional interpretation.
An embargo which is not visible in Article 200, why do you want to read that embargo
May
on
I-
governor's power? If you want to, according to you, the governor has very wide optional powers there. So today, why, as my brother Vikramanath has pointed out, today he decides to withhold it, withhold it because he knows that this act in the present form cannot be allowed to be passed. So he withhold it. After that, there is a deliberation, there are examinations, and then he finds that partially it can be modified or substantially it can be replaced. And then he gives a chance to the assembly that now he can go ahead.
Thereafter, he loses his right of withholding.
Look, but a governor can absolutely also come to a conclusion that a bill in its entirety needs to be withheld. It
That-
need
that's
not
what-
be sent back.
That's what is argued by the learned solicitor.
So suppose it's,
That is why withhold has been used. Otherwise, he would decline to grant assent.
Otherwise, the main body.
Why word withhold?
Withhold, no, the main body could have said withhold and return.
It's after bhajanlal.
The main body,
Right.
the main body could have said withhold and return.
Call it is better than I think we.
Yes, well, no, I thought there was.
Yeah, first let the solid come to you as per your turn.
this. So these are the judgments, my lord, I have cited. Lord, now please come to,
We are through with all the judgment.
on this, my lord, 200, on options, my lord. I was reading, my lord, last, the judgment in Punjab, my lords.
Then no, para 25 would also be important that.
I'll read it, my lords. 176.
176.
Yes. The governor, as an unelected head of the state, but is representing the president who is appointed by, who is first of all elected. Let us understand this, my lord. My lord, this is the impression which is carrying in everyone's mind. That governor is an unelected man, what can he do? What are his powers? But we must understand, he is
He is
the
the representative of the central government there, he is the representative of the.
No,
of the
something
president.
else. He is representing President of India. President of India is elected indirectly by the entire nation, and President acts on the aid and advice of the Council of Ministers, which has the electoral mandate. So he is not just a nobody or a
No,
postman.
nobody says, nobody, they are only said that he is an unelected head of the state.
That word,
The scheme which you took us yesterday clearly showed the distinction between nomination and the election.
I understand.
And the Constituent Assembly decided to go by nomination and not by election.
I bow down.
So therefore, he is, as a matter of fact, he is nominated.
My lord, this word unelected, my lord, in case of executives at least, my lord, is always used, my lord, as if
Like
he is
we
power.
are appointed by the president, not elected.
My lord,
What is wrong in that?
Lord, I'll not, my lord, go into it, but therefore I said in case of executive, unelected is used as a.
So we won't go into that aspect.
Yes,
We
but
go
the
as-
governor,
So unnecessary to take up that.
not necessary, my lord, your lordship, sorry. The governor as an
The
unelected,
better would have been the governor as a nominated head of the state.
anyway, my lord, it's, my lord, anyway, my lord, I'll not elaborate it further. Governor as an unelected head of the state is entrusted with certain constitutional powers. However, this power cannot be used to thwart the normal course of lawmaking by the state legislature. There cannot be any doubt about, my lord, this proposition. Consequently, if the governor decides to withhold assent under the substantive part of Article 200, the logical course of action, what is not interpreting, according to the bench, the logical course of action is to pursue the course indicated in the first proviso of remitting the bill to the state legislature for reconsideration. So the court says he is unelected, you cannot thwart the elected person's process, and therefore as a logical consequence, you resort to the proviso. The logical course of action is to pursue. In other words, the power to withhold assent under the substantive part of Article 200 must be read together with the consequential course of action to be adopted by the governor under the first proviso. If the first proviso is not read in juxtaposition to the governor, to the power to withhold assent conferred by the substantive part of Article 200, the governor as the unelected head of state, again, my lord, this is weighing with everyone. State would be in a position to virtually veto the functioning of the legislative domain by a duly elected legislature by simply declaring that assent is withheld without any further recourse. This may not be, Lord, in view of the bench, a possible course of action in a democracy. But then the remedy lies, my lord, in amending in the political process, not by way of, my lord, interpretation of the judgment. Such a course of action would be contrary to fundamental principles of a constitutional democracy based on a parliamentary pattern of governance. Therefore, when the governor decides to withhold assent under the substantive part of Article 200, the course of action which is to be followed is that which is indicated in the first proviso. Please pause here for a minute, my lord. If this is law, then your lordships would be rendering, interpretation of your lordships would render the power of withhold redundant, because if power of withhold is to be read with the proviso, the moment I resort to the proviso as a governor, I lose my right of withhold, because then I have no option to withhold. Lord, then how do we give meaning to the first part, the second option, withhold? If withhold has to follow, Lord, the proviso.
That's what I said. Withhold may not necessarily follow the proviso. Withhold can be a clear and discrete withhold. That's it.
Correct, my lord.
But it
Possible.
can also be attached to the proviso.
Then, my lord, the governor, my lord, then
It's at the
should be
wisdom
clear.
of the governor or his discretion, what he wants to do. He wants to withhold for the time being, exercise the proviso and proceed
Permanent.
further. Otherwise,
He may take a call that this is a case where I will, rather than blocking permanently,
it's also open to him to clearly say, all right, just declare that it is withheld, finish. And not exercise the proviso.
yes, yes. And I'm grateful, but that's the submission. But if he chooses to go as per proviso,
For all the constitutional benches said,
Unless.
withhold unless
Unless,
he has exercised the proviso.
Lord, otherwise, but when he chooses to go for the proviso, he loses the right to withhold it thereafter. If he wants to withhold, it has to be at the outset, but in a given facts of the case, he may choose that, all right, I'll lose my right of withholding. I will eventually refer it to the precedent.
So according to, at the threshold, he has to exercise one of the four options. Either
Three
to give,
For four options, yes, one of the four options.
either to give assent, or to withhold it, or to send it, refer it to the president,
And
or fourth, to refer it to the legislature to reconsider it with his message.
And fifth, my lord, as my lord Justice Vikramnath has suggested, that I forego as a governor, I means the governor forgoes the permanent withholding,
So not fifth, that will be the part of the fourth, the proviso.
oh, that's four.
but then I will not withhold. I will not be able to
So
withhold.
therefore, yes, once you decide to exercise the fourth choice of sending it to the governor, you are dependent on what the legislature does.
Absolutely.
If it comes back as it is,
Economic development.
you are bound to,
As it is or with amendment, it has to
No,
be.
then I will have two options. Governor will have two options, either to grant assent or
to refer it to the
withhold.
president.
Because that is not prohibited under the proviso. Lord, can I start tomorrow? Pardon?
As per the timeline, I think by Tuesday, your
We
side.
will not cross the time allotted to us together. The lordships have given 4 days.
Yes.
Today is the second day. We will so adjust, my lord, that